Academy. So kindly consider at 12 o'clock.
Pardon, my lord. This is also the assignment of Justice R.K. Patnaik, my lord. This is a special case because there was a lady constable. She has been serving now at a Swakati. With the in terms of this Hon'Ble Court, she has been brought to Swakati. So that is why, out of grudge, the 10 years back proceeding has been initiated against him just to to kick him out from service, my lord. So this is very urgent in nature.
So what are you challenging?
Well, I'm challenging the proceeding of 10 years, my lord, that they have initiated now. Can it be taken up?
What is what is the urgency there?
Urgency is not the punishment. I only pray, my lord, that any course of action or punishment they will take, that will maybe with the leave of this court. I don't pray many things.
No, why will they leave of it? The employer is entitled to proceed.
No, but the law demands that it should be finished within 1 year, my lord, 6 months. Now it is 10 years back proceeding that they're initiating only with the initiative to harass me, my lord. The poor lady constable, that is the only reason. If not today, can you also pick it on Monday?
Yeah. No.
Actually, this is a
This matter on Monday.
the second appeal of 2024 for fresh admission. The urgency is that the appellants are now residing in US. They want to come back to Odisha and reside in their own self-acquired property, which is being forcefully not being let out by their own
It has not
system.
been admitted.
No, it has not been. A fresh admission.
Yes.
Supplementary list item number 1 for judgment.
Thus, from a conspectus of the analysis of facts and law and the discussion made thereon, this court is of the view that the impugned judgment passed by the first appellate court does not warrant any interference whatsoever. Resultantly, the second appeal being devoid of merit is therefore dismissed. There shall be no other restrictive cost.
Item number 2 for judgment.
In the result, the appeal succeeds and is therefore allowed. The impugned judgments are set aside. The suit filed by the plaintiff is decreed by declaring his right, title, and interest of the suit land. Further, the defendants are directed to hand over vacant possession of the suit land to the plaintiff within 3 months, failing which it shall be open to the plaintiff to enforce the decree in accordance with law. There shall be no order as to cost.
Item number 3 for judgment.
For the foregoing reasons, therefore, this court finds no reason to entertain the writ petition at this belated stage, which is therefore dismissed. There shall be no order as to cost.
Item number 4 for judgment.
In the result, the writ petition is allowed. The impugned list under Annexure 5 only insofar as it relates to the petitioners is hereby quashed. The opposite party authorities are directed to consider the candidature of the petitioners for the post advertised and pass necessary orders in accordance with law within 2 months from the date of production of certified copy of this order by the petitioner. Yes.
Item number 5, fresh admission.
Wait, please. There are 2 TRPCs, one filed by the husband, one filed by the wife. Husband has filed a Section 9 petition at Bhubaneswar. Wife had filed a divorce petition at Sambalpur. In the meantime, divorce has been allowed. So both the TRPCs remain infructuous.
Yeah. Arata is not your matter. Arata says Mr. Paddy should have appeared. Is he appearing?
No.
Your matter I can dispose of. The other matter, I'll keep it to next week separately. He may have missed the list also. Sri Agarwal, counsel for the petitioner, submits that since in the meantime, the divorce proceeding preferred by the husband.
No. Divorce petition filed by the wife.
Divorce petition filed by the wife has ended in a decree of divorce.
Please here.
The transfer application has become infructuous. The same is dismissed as such. Same.
Divorce to allow agency. Section 9 would have not filed copy.
I will take instructions, Lordship.
All right, next week. I next week, when a common connected matter, next week as well. Your matter is dismissed.
Item number 6.
One is the legally wedded wife of opposite party number 2. Opposite friend or opposite party is filing this case for transfer of the CP pending before the Lord and Family Judge Kotak to Balaswar Mala. In para 8, I have mentioned that DV case is pending there, and also Restitution of consumer.
Right notice. Issue notice to the.
I will take instruction in this case. I will appear. Can you take on next week? I will file my MK
Your good name, sir?
Swami.
M?
MK Swami.
All right. Sri M.K. Swami, Learned Counsel, submits that he has instructions to appear for the opposite party husband and that he shall file power next week. List this matter on what according?
Next week I needed one.
List this matter on 12 July.
My lord, I have
Let
filed.
a copy of the transfer application be served upon Sri Swami
I am just,
by Monday. Yes.
sir, I have filed a miscase that is numbered today,
Huh.
not. And for
Fine. No, nothing. You have filed it in the.
counter, my lord, and that is also number.
Huh? I am passing it over. I am calling for that IA. Let the IA come. I will pass that out.
I have already numbered my.
No, number is our record nahi na. Order can pass ho. Our record nahi. So let the IA come. I will magi din. Item magi din. So I will pass whatever interim order I can. All right.
Chapter for
Pass over iglo.
तीन चारटा possibility sir.
आया?
तीन चारटा परे sir ठीक kindly
Next.
आगे time लगियो जाइकी सिटु आसीबा पे टी time लगियो आ सेंत कहले हबो आज्ञा.
sir Monday.
All right. Place this matter on Monday along with the IA said to have been filed by the petitioner. Yes.
Item number 7.
Matter relating to selection of Sikha Sahib.
Yes.
And last occasion, your lordship has directed to produce that communication of the RTA application.
No, what is the same to order direction nahi? Khalithala list this matter on 28/6.
The impugned order is under Annexure 12. It is applicable.
Annexure 12, yes.
Madam. The operative person is at page 39. Starts from page 38, paragraph 6.
Or that you are, they claim that you have never offered your candidate.
Yes, lords.
So what is your instruction?
No, my lord.
Your lords directed me to produce that RTA application which has been communicated to the
disclose this
petitioner.
particular stand about the state authority.
Okay. Sir, ठीक है kindly. I am getting disturbed. Yes. कौन है RTA application?
RTA application रे मोर जो नाटा थिला मु गोटे 100 seats रो गोटे application register receipt register गोटे copy आनी थिली. सेटा that has been produced before the OP number 1 which has not been considered while passing that time.
Let us see.
सेटा गोटे कहिथिले मु by memo आनी.
Italy will dispose. I will direct him to consider it again. Or I am to furnish you with the information available in the time. Information again.
सेटा देले मु annexure करिछि.
That is annexure.
Annexure हेइथिला. Annex 13 हेइथिला बट एइटा न.
अच्छा.
The forwarding letter टा जो
Forwarding letter टा मते कहिथिला ने. मु
Okay, I remember.
Right.
इथे कोथि अछि आपन नाटा आगे 106
99 again.
99
Sir. 99 page 45.
is 45.
Sri
Ragini Naik.
Yes. The counsel for the petitioner files a copy of the forwarding letter of the PASS section,
Sarva Sikha Abhijan.
SS section, SS Bhadrak, dated 22/7/2022.
Now it has been Samagra Sikha.
Sir, this is addressed to the PIO.
PIO ସେଇଠୁ ଆମକୁ ରିସିଭ୍ କରିବାକୁ ପଡୁଛି. ଦେଖୁନାହାନ୍ତି ଏନକ୍ଲୋଜର
PIO ଗୋଟେ forwarding letter ଦେବେ ନା?
PI ଗୋଟେ forwarding letter.
PIO ଗୋଟେ
ସେ ଅଫିସରୁ ଆମେ ରିସିଭ୍ କରିଛୁ.
ନାଇଁ ରିସିଭ୍ କରୁଛ PIO ଗୋଟେ forwarding letter ଦିଅ.
ସେମିତି କିଛି ଦେଇନାହାନ୍ତି ଅଫିସ ରେଜିଷ୍ଟରରୁ କହିଲେ 100 pages.
Let them consider.
ଆଜ୍ଞା.
କଣ ଲେଖିଲେ? Forwarding furnishing the information sought for by the petitioner's father in 100 pages. So the copies of the information, copies of the relevant information have been enclosed to the writ application under annexure 13, the memo be kept on record.
ଆଉ 14 ରେ ମୁଁ ଦେଇଛି
ଆଜ୍ଞା?
ଆନେକ୍ସର 14 ରେ ମୁଁ ତାଙ୍କୁ ଦେଇଛି ସେଟା ଓପି ନମ୍ବର 1 ପୋଷ୍ଟାଲ ରିସିପ୍ଟ ଆଉ ଟ୍ରାକିଂ ରିପୋର୍ଟ ବି ଅଛି
This information was furnished pursuant to letter dated. Date ta kete mu? To a letter dated 31/7/2022 submitted by the petitioner to the Principal Secretary to Government in Department of School and Mass Education, comma, copy of which has been enclosed as Annexure 14. Stop. It is submitted by learned counsel for the petitioner that the case of the petitioner is that pursuant to advertisement published for engagement of Sikha Sahibs in the year 2011-12, the petitioner had submitted her application as would be evident from the application receipt register, wherein her name is placed at serial number 99. Stop. Since she was not selected, she approached this court. Where is the impugned order?
Annexure 12, my lord. They are not
She approached this court in WPC number 12409 of 2021, which was disposed of by order dated 6/4/2021, directing the collector the
ନା ଓପି ନମ୍ବର 1
open number 1 key,
ସେକ୍ରେଟାରୀ
directing the secretary of the department to consider and dispose of the representation submitted by the petitioner in accordance with law. Pursuant to such direction, the secretary, by order dated 28/3/2024, comma, which is impugned in the present writ application, rejected the representation of the petitioner on the ground that there is no proof that the petitioner had submitted her candidature for engagement as Sikha Sahayak. It is submitted by learned counsel for the petitioner that this finding of the above finding of the secretary is entirely contrary to records, as would be evident from the information obtained obtained by the petitioner under the RTI Act. Sri S.N. Patnaik, learned AGA, submits that the online application thila ki
ନା ସେତେବେଳେ ଅଫଲାଇନ ମୋଡରେ
that
Our stand is that, madam, para number 6.
what is your stand?
Para number 6 of that impugned order. And page number 38. There was chance of personal hearing. And she remained present in that particular.
That the petitioner had personally appeared before the secretary and submitted a written statement, but could not prove that she had applied for the applied for Sikha Sahayak, for engagement as Sikha Sahayak at the relevant time. After perusing the documents and information obtained, after perusing the information obtained by the petitioner under the RTI Act, as enclosed to the writ petition under Annexure 13, this court prima facie finds that there is proof, that there is prima facie proof of the petitioner submitting her application at the relevant time, which was also duly received and endorsed in the application receipt register.
Date भी अच्छी
Application receipt register.
left side पे देखो
It further appears that as per said information, the petitioner submitted her application on
3/2
February 2011.
कोई लिखा है
left side रे देखो
पूर्व पेज रे
अच्छा on 3/2/2011. This fact was obviously not this fact has obviously not been considered by the secretary, for which the impugned order becomes susceptible to challenge. For the foregoing reasons, therefore, the writ application is allowed. The impugned order under Annexure 6, Annexure 12 is hereby quashed. The matter is remitted to the Secretary, Department of School and Mass Education, Odisha, to reconsider the representation of the petitioner by calling for the relevant records from the concerned authorities regarding receipt of applications from candidates. Stop. The opposite party, the secretary shall also consider the original documents obtained by the petitioner under the RTI Act to be filed before him in course of personal hearing. Stop. The representation shall be finally disposed of within
2 months.
Within 2 months, yes, shall be disposed of within 2 months from the date of production of certified copy of this order by the petitioner. Yes. ये record हो रहा है ना?
Item number 8.
May I please, let's. My lord, may kindly have a glance at page 16, Annexure 2, my lord. Yes, sorry. Page 11, Annexure 1, my lord. This petitioner, he is a ENT. He has completed his my lord, post-graduation in ENT, and he has gone for a super specialization special course. Here, my lord, may I place, my lord, that first paragraph. What the director Acharya Harihara has floated this advertisement. There they have mentioned the candidates who are continuing as faculty in any of the government medical colleges of the state, Vimsar, Bulla, either on contractual or deputation, are not eligible to apply. My lord, the meaning of this has been floated by director. On previous occasion, the director has requested DMET, Director of Medical Education, to float advertisement for the same institute, that is at Annexure 2, my lord. My lord, this has been explained. Who are not allowed. There, my lord, it has been mentioned the candidates who are continuing as faculties in any of the government medical colleges of the state, Vimsar, Bullar, HPGI, Cuttack, either on contractual deputation, are eligible to apply for the higher level post only. This has been missed in the previous advertisement. The intention is that suppose a person is working as contractual or deputation basis, suppose a surgery, assistant professor in surgery, he will not be eligible to the post of assistant surgeon in surgery in Acharya Harihara, but he will be eligible for any higher post, or they have said the higher level post, that is the super specialty post. Here the petitioner was continuing as ENT specialist, assistant professor in ENT. Now, this first advertisement, which has been issued by the director, the petitioner has applied for assistant professor in head and neck surgery. That is a super specialty course. 3 posts were advertised. Now, what happened? Out of 3 posts, the date was fixed to 27th of June, And before applying for the same, he applied for NOC at Annexure 3 to the principal, which has been forwarded to the DMT at Annexure 3 at page 22. NOC to appear. Then, my lord, on Annexure 4, the interview was on 27th. On 26th, my lord, he was on leave for some. He was on leave and he joined on 26th and filed his joining report. And on the same date, he filed his resignation. My lord, at Annexure 5 at 24th, and that has been accepted by the principal. And at Annexure 6 at page 25, that has been accepted and forwarded to the DMT. In the meantime, on 27th, he appeared in the interview, which he was allowed.
Why did he resign?
Resign kala se hochi ENT re achi goto government medical college re contractual basis re. This is a higher post. Head and neck.
So, जो 12टा ରହିଲା ଯେ यदि government
government re यदि assistant professor तुमे थिबो ताहले you will not be eligible. But here ये जो गोटे लाइन जोटा कि डायरेक्टर छाड़ देछन्ती DMT who is government सीए निजे ही ताकर सेम एडवर्टाइजमेंट गोटे सिमिलर एडवर्टाइजमेंट कहिसन्ती कोइ माने एलिजिबल नो if someone is those who aspire for a better post or higher level post, they will be allowed. I am in ENT, assistant professor ENT. I have applied for head and neck surgery, assistant professor head.
But it is not there specifically in the advertisement. That may be there in the DMT's advertisement, but how is it relevant for you?
DMT advertisement for the same institute.
How can there be two advertisements?
Seta purbo advertisement.
So how is it relevant for you?
I am explaining who are not allowed. According to government, because Acharya Hariyar is a society. For some reason, for government not to disturb the government, they have included this clause, and government itself has explained in a similar advertisement who are not eligible. That's what I.
So what happened? What happened?
What happened thereafter, my lord? On at Annexure, my lord 7, the provisional list was published, where in this said discipline, one person was selected. My lord would find it at 27, page 27. Three vacancies were there. One was selected. Annexure 8, my application, my candidature was rejected. Page 28, serial number 4. Sukumal Das, head and neck surgery discipline, already assistant professor, contractual in government medical college. This is the only ground.
So this was published on 17/5/2024.
My lord.
When was your resignation accepted?
Resignation, my lord. Page 25, my lord, Annexure 6. That is on 3/6/2024.
No, that was accepted on 3/6/2024. So as on the date of consideration, no, he has submitted his joining. Oh, not accepted. He has submitted only.
He submitted his representation saying that is pending for consideration.
No, the principal, I had submitted it to the principal. Principal has forwarded to DMT. That is the stage, my lord. What exactly I beg to state, my lord, is that government who doesn't have any problem, government allows such type of candidates like me to go for a higher course. My lord, this is directly debarring me to go for a better post.
You should have challenged the advertisement.
Seta se
You should have challenged the advertisement.
Say jo
You know the legal implication. Unless you challenge the advertisement.
Kintu say jo seta that I am trying to explain it. Say jo debar ta assistant professors are not allowed. I accept that. I bow down by the clauses of the advertisement. But I want to explain the fact that I am not the person who should be considered in that debarness. Because that has been explained by the government itself.
Difficult case.
Government has.
I will ask them to take instruction. That's a different matter, but difficult case.
এটা ତାଙ୍କ ପାଖକୁ ଯିବ ନୋଟିସ ସ୍ପେଶାଲ ମେସିନରେ ନେକ୍ସଟ ୱିକ୍ ରଖିଲେ ନହେଲେ ମୁଁ ଦସ୍ତି ସର୍ଭ କରିଦେବି। ଏମିତି ବି 3ଟା ପୋଷ୍ଟ ଅଛି ତାଙ୍କର ଜଣିଏ ପିଲା ସିଲେକ୍ଟେଡ 2ଟା ପୋଷ୍ଟ ଖାଲି ପଡୁଛି। ସୋ ମିସଅଣ୍ଡରଷ୍ଟାଣ୍ଡିଂ ରେ ସେ ତାକୁ ଇଏ କରୁଛନ୍ତି ଆଣ୍ଡ ମତେ ସେ ଡିଭାର କରୁଛନ୍ତି ଫର ଏ ବେଟର ପୋଷ୍ଟ।
You can accept notice for opposite party number 2.
ତାଙ୍କର ସ୍ପେଶାଲ କାଉନ୍ସିଲ ଦିଅନ୍ତି ଓ ଡିଏମଟି ପାଇଁ ଆଜ୍ଞା।
I can only appear for DMT.
ଆଜ୍ଞା।
Issue notice to opposite party number 1 by special messenger, the cost of which shall be assessed and deposited by Monday. ଆଉ ତାପ ଆଜି ଆମେ ହେଇପାରିବ by Monday। କାଲି କଣ ଆମ working day ଅଛି ଦେଖିଲ ମାନେ ଅଫିସର working day କି କାଲି ନା ହବନି କାଲି last Saturday ହବନି। So Monday by Monday. Sri S.N. Patnaik, Learned AG, accepts notice on behalf of opposite party number 2. List this matter on next Friday. Go to Koro. Next Friday.
Aye.
Kete.
ମୁଁ ସେଇଟା 10 ଟି ସର୍ଭ କରିଦେବି ସ୍ପେଶାଲ ମେସେଜ
Kod.
ଆଇ
Dasti in addition is allowed.
5th July.
Eh?
5th July.
List this matter on 5th July. आइए notice as above. What interim orders? ये दीटा तो vacancies
ହବନି
ଅଛି.
fill up
Notice as above.
ସବଜେକ୍ଟ ଟୁ ରିଜଲ୍ଟ ଏମିତି ବି fill up ହବନି ସେ ଗୋଟେ ମାସ ଭିତରେ
ସେଦିନ ପାସ୍ କରିବା ସେ ଅର୍ଡରଟା
ଆଜ୍ଞା,
ସେଦିନ ପାସ୍ କରିବା
ଆଜ୍ଞା।
notice as above.
ଆଜ୍ଞା।
Yes.
Item number 9.
But I think ମାନେ off the record
ଆଜ୍ଞା
your client committed a mistake.
ହଁ I know that.
It will be very
They
difficult.
should have challenged it.
You see, it will be very difficult to now enter into that.
Consider କିନ୍ତୁ ସେମାନେ କରିପାରିବେ କାହିଁ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ପାଇଁ ସେ କରୁଛନ୍ତି but government don't
ସେ
have-
କାହିଁ କରିଛି ତମେ ବୁଝିବ ନା?
ଆଜ୍ଞା
କାରଣ ସମସ୍ତେ ଛାଡି ଦେଇ ପଳେଇ ଆସୁଛନ୍ତି।
ଆଜ୍ଞା ଆଜ୍ଞା କିନ୍ତୁ ଏଇଟା ବି ସେଇ ଏଇଟା
ଚାରିଆଡେ ବହୁତ ବଡ ବଡ ସବୁ ମେଡିକାଲ କଲେଜ ଖୋଲା ହେଲାଣି କିନ୍ତୁ ତାର ନା।
it is more or less ସେଇ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କାରଣ ଆଚାର୍ଯ୍ୟ ହରିହର attached to SCB.
Yes, what is this?
My lord, here a similar matters my lord have been pleased to direct number of orders para 10 11 12 ମୁଁ mention କରିଛି the exact order
What are you challenging here? What are you challenging?
my lord, he wants to go for a fellowship program in LV Prasad. His application is pending. He has to join on 1st of July as per Annexure 2. Exact same matter, my lord. This orders has been passed. Number of cases orders has been passed. This is the exact same institute.
Have you seen this one?
Only my lord, the 1st July ରେ ଅଛି ଗୋଟେ week ରେ ତାଙ୍କୁ ଦବା ପାଇଁ ଖାଲି ଟିକେ direction ଦେଇଦେବେ।
So they have to consider your case. They have already.
ଖାଲି time ଟା ଟିକେ 1st July ରେ ଯେହେତୁ ତାକୁ
Petitioner
ଅଛି
has approached this court. ଏମିତି ଲେଖନ୍ତୁ the petitioner is working as
ସେ ଅଛି DHS ଭଦ୍ରକର specialist in
he is working as a specialist in ophthalmology at DHH Bhadrak.
ମାନେ ସେ
He-
ସେଠି ମାନେ ସେ ଟିକେ ସେଠି he has been deputed to MKCG Medical College Berhampur ସେଟା ତାର original post ଏବେ deputed to MKCG Medical College Berhampur.
Presently, he is on deputation to the MKCG Medical College and Hospital at Berhampur. Stop. He desires to pursue a fellowship program in the Department of Ophthalmology at LV Prasad Eye Hospital, Bhubaneswar. Pursuant to an advertisement issued on
ସେଟା ସିଲେକ୍ସନ ସାର୍
Huh?
ସିଲେକ୍ସନ ସେଟା ଅଫର ଲେଟର ତାର Annexure 2
being selected as per letter dated 30/5/2024 of the competent authority of said eye institute. He, as per the rules, he has submitted application before the Commissioner cum Secretary, Health and Family Welfare Department on 31/5/2024 with request to grant him no objection certificate bracketed NOC for the purpose of pursuing the fellowship program. So, Mr. Learned Counsel, appearing for the petitioner, submits that the fellowship program is scheduled to commence from 1st of July 2024, but no action has been taken on his request for grant of NOC as yet. Stop. Sri Patnaik Learned State Council submits that NOC can be issued only if the rules permit. Stop. Moreover, there is shortage of doctors in the state. This court finds that a coordinate bench of this court in the case of Dr. Ankita Mahapatra versus State of Odisha, another detail. Dealing with an identical issue has directed the authorities to consider the case of the petitioner and to grant NOC if the rules so provide. Stop.
In absence of any bar, he has decided.
Since the State Council has not been able to demonstrate that there is any bar for a doctor serving in a government hospital to undergo fellowship program in a private institute, the writ application is disposed of, directing the secretary of the department, bracket opposite party number 1, to consider the representation submitted by the petitioner and to grant NOC for joining the fellowship program if there is no legal impediment. There is no legal impediment. Stop. Considering the fact that the fellowship program is scheduled to commence from 1st of July 2024, the secretary shall do well to take a decision in the matter before that date. Stop. For the above purpose, the secretary shall act upon a certified copy of this order to be presented by the petitioner. That's all.
Within 1
Aye?
within a week.
ଆପଣଙ୍କର 1 ଜୁଲାଇରୁ ଆରମ୍ଭ ତ? ଆଉ ଟାଇମ୍ କାଇଁ?
ନାଇଁ ମୁଁ କହିଲି 1 week ରେ କହିଲି।
1 week କହନ୍ତୁ ମୁଁ କିଛି କହିଲିନି ଆପଣଙ୍କୁ ଦେଲି ଆଜି ଆପଣ କାଲି ନେଇ କୁହନ୍ତୁ କାଲି ନେଇ ଦିଅନ୍ତୁ।
May place one thing, the Ankita Mahapatra mentioned pursuant to orders passed by this honorable court, she has been also issued.
ସେଇଟା ଗୋଟେ ଲେଖି ଦିଅନ୍ତୁ ସେ ଯୋଉ ଲେଖିଲେ coordinate bench of this court last ଲେଖିଲେ it is submitted by Sri Mishra that the petitioner in the said case, Dr. Ankita Mahapatra, has been granted NOC in the meantime. Pursuant to
orders passed.
The above order. Hello.
Decree. Urgent public.
Item number 10.
May I please, Your Lordship? Your Lordship, kindly recollect this petitioner is going to retire on 30th June, on Sunday, and Lordship on 26th has been pleased to direct my Lord to take instruction because on 26th there was a meeting. 26th.
Order sheet
That has not been uploaded late. It's
Sir, I have just now received my letter. Before just 1 minute.
recommendation, regarding age though?
Yes.
Sir, as per the information provided by the concerned section, a committee is constituted to look into the matter of various societies having, however, no formal proceeding of the meeting is out yet.
Has been?
No proceeding has been out yet.
No proceeding has been?
And the proceeding the result of the proceeding has not yet been published.
No, but he's going to retire. A question of age is there.
Moreover, they mentioned that till any policy decision is taken by the government, the individuals working on the various societies are to be guided by their own bylaws. Because, my lord,
he will go out of employment.
But anyway, my lord, this particular policy decision, if it is going to be taken in favor of the persons, that can be only prospective. Those
See,
persons who are still in service,
prospective mean it will affect all those who are in employment.
those are who are in employment, because Adon date no,
Retrospectively, Mr. Mahathi is also very fairly, he submitted on the last occasion that if the rules, if they take a negative decision, then he will go out of employment.
Adon date is when there is no such decision.
সে কথা কি মনে করছি? So no,
Kindly be protected, my lords.
how can you be protected? How can you be protected if the rules do not permit you to?
Adon date, my lord,
I am from authorized, my lord.
You will do one thing.
Yes.
We'll keep it pending.
Yes, that's
We'll keep the writ application pending. You file a counter, we'll see.
Yes,
But I cannot grant you any interim relief.
Your lords, I am conscious, my lord, your lordship.
It will be very difficult. I mean, it will be going against the
On
rules.
30th, yes, on 30th I am going, lord, so on Sunday. So on 26th, the meeting has been taken away on place.
No.
I have filed that day.
What is the proceeding?
that has not been finalized, my lord.
Lord,
That
this
is
cannot
what-
happen.
my lord,
ସେ କିଛି କରିନଥିବ
foreign answership में ସେ ଦେଇଛନ୍ ମତେ
And the-
ଏଇ ଜିନିଷ
lords,
ଏ ବନ୍ଦ କରି
ଖାଲି request କରି
ବନ୍ଦ କରି
for a moment, lordship,
କିଛି ହଉଛି
it has to be submitted within 15 days. And so production of report, it has been fixed to 26/6.
I'll simply keep it pending. ଆଉ କିଛି କରିହବନି
As your lords.
CSN Patnaik learned DGA submits on instructions that the proceeding of the meeting ହେଇଛି କି ନାହିଁ ଜଣା ପଡୁଛି
ସେ meeting ଯାଇଛି ପରା
that the meeting
a committee is constituted
କଣ
but
the
no
constituted
formal proceeding of the meeting is out with
that
that is the land.
the proceeding of the meeting supposedly held on
26th
26 June has not been received as yet. He requests for some time to produce the minutes of the meeting. We'll keep it a very short date, huh? Gote week chhadi ki taपर रखंदो. In the meantime, whatever, jadi he has fairly submitted that if the government takes a policy decision, then it has to be challenged, otherwise you can't do anything about it. So I will just simply keep it pending. Place this matter on
12th July.
Huh?
12th July.
12 July is the earliest.
Yes.
12 July.
So for IA is concerned, it has to simply.
आइए आइए कौन करे
Is notice also, at least for, because
then state council shall also take instructions on the IA.
I know, my lords, the difficult.
No, it can be because if the rules do not permit,
No, my lords,
the court cannot go beyond the rules to say that you continue.
I am very much conscious on my submissions.
But may I
What?
pray, my lord, a free copy of this error may be provided to
Yes,
me.
yes. The free copy of this order be handed over to.
ମୁଁ ମୋ
Free
ଲେଟର ଟାକୁ ଟିକେ ଏକ୍ସପିରିଏଟ କରିବା ପାଇଁ ମୁଁ ହ୍ୱାଟ୍ସଆପ ରେ ପଠେଇଲି ଯେ ତା ଉପରେ ନମ୍ବର କାହିଁ ନାହିଁ ବୋଲି ସେଟା ରେସ୍ପଣ୍ଡ କଲେନି।
Yeah, but the state government accepts WhatsApp. Anyway, we'll see. Yes.
Item
Great.
11.
Item 11.
And the petition challenge the issuance of second so-called notice.
Directing to separate charge member inquiry purpose. Yes.
ମାନେ ତ
देखो मेमो
ଚାଲିଛି ତ
ଆମେ ଆଲୋକ କରୁଛୁ ମେମୋ ଆମ ଆସାଇନମେଣ୍ଟ ନୁହେଁ ତାହେଲେ ସେଇଥିରେ ସବୁଥିରେ ସେଇ ଯୋଉ ଆମର ଯୋଉଟା ଆସାଇନମେଣ୍ଟ ନୁହେଁ ସେଥିରେ ଉପରେ ଲେଖା ହବ ସେଇ this is not assigned to this court, however mention being made by the learning council yesterday and in view of the special notice it has been taken out. ସେଇ ଯୋଉଟା କରିକି କରିବୁ
8, 9, 10, 11 ସବୁ ଯାକ
ନାଇଁ ସେଟା ଲେଖିବାକୁ ପଡିବ ନା order. This is not of my assignment.
କୋଡ୍ ନମ୍ବର 10 ମାନେ
ମୁଁ ଜାଣିଛି ଏବେ ମୋ କାମ କରୁନି ମୁଁ ଆପଣଙ୍କ କାମ କରୁଛି କୁହନ୍ତୁ
ମାନେ the petition prayed by the challenge the issuance of second so-called notice by the discipline authority matter. Well, initially the charge memo has been filed against the petitioner that when he was working as sub-inspector on police cycle outpost matter, allegation has been made that he was not registered an FIR of the 420 case and he had received 2 checks from the informant for settle the matter. But subsequently the FIR has been lodged against the concerned SI. Then the department procedure has been initiated. Matter. The fact is that the concerned petitioner, after receiving the information from the informant, stationary entry has been registered and that he will investigate the matter. Then according to the request of the informant, he has received 2 checks that matter will be settled. And in the meantime, he has been transferred to another police station matter. Thereafter, inquiry has been conducted, and after the inquiry, my lord, the inquiry officer have opined that is annexure 7, my lord, that according to the past records of the petitioner, lenient view can be taken. But the disciplinary authority, that the Superintendent of Police Keonjhar, has opened the issuance of second so-called notice that why he will not be removed from the service. That is,
He has given the reason.
my lord.
He has given the reason. If he differs from the finding of the recommendation of the inquiry report, inquiry officer, then he has to give reasons. He has given reasons.
Expand that is
SI collected 2 bank checks from the general public with intention which amounts to serious misconduct affecting the outside public. Hence, with the due application of mind and excessive power in PMR 825, directed to show cause. What is wrong with it?
And my lord, it's moreover, my lord, it is also premature.
the premature.
Till date,
Hmm.
only in BK Khana case, my lord.
Hon'Ble
There it has been stated that court can interfere at the stage of charge even. Where the author in case of lacking of authority or if it is against the rule. But here it is a case, my lord, where the charge has been framed and principle of natural justice has been followed. PW, DW, everybody has been examined and.
No, that is what I was going to ask him. What is wrong in it?
So, my lord, it
What
is
is wrong in the second show
minor
cause?
stage.
second
And it's, the final order is also.
Mobile টা বোঝাতে
removal from service, my lord. That is the Hon'Ble
removal of service or
that after so cause he said that the explanation given by the concerned person is unsatisfactory, then he will remove from service. By Hon'Ble before also the notice can be issued, but till disposal of the writ petition, no action, no order will be passed by the concerned authority. That is my prayer, Hon'Ble. Otherwise, he will be dismissed from the service, my lord.
No, he will be removed from service. He deserves to be removed from service.
My lord,
ये पैसा खाई उसे तो वही बना
that is total no false, my lord. I have
पूरा total false है
given my total my
check reference
instruction also.
Sri S.N. Patnaik Learned AG accepts notice on behalf of all the opposite parties. It is submitted that. Where is that inquiry report?
Inquiry that is 7, my lord. 44, page 44.
Where is the recommendation?
That is so cause notice, my lord, annexure 8, my lord, 54 pages.
Well, the recommendation is at page note.
Admonition. It is submitted that
Page note 51,
In
the discussion, page note 51.
in the query, the inquiry officer, after finding the petitioner guilty of the charge, recommended that the case may be viewed leniently with admonition, taking into account his previous unblemished service record and the degree of delinquency. The disciplinary authority has, however, proposed an extreme punishment of removal from service, which is not commensurate with the charges proved. So, शर्मा 1000 टଙ୍କା दिवत जाकी मुई जानी गोटे रसीद दाखल करूँ बार एसोसिएशन बार एसोसिएशन को दियंतु 1000 टଙ୍କା Sri S.N. Patnaik Learned AG accepts notice on behalf of issue notice Sri S.N. Patnaik Learned AG accepts notice for all the opposite parties. List this matter on
26 July.
26 July. Aye. Till such time, no course of action shall be taken against the petitioner. Yes.
Item 12.
Here, my lord, the petition challenge the annexure 3 at page 19, my lord, official order where it is directed to the written my lord, the petitioner my lord, on completion of the 58 years my lord. Then my lord, annexure 4,
You are working as what?
I am the working as employee my lord, under rubber board my lord. Which is, then my lord, annexure 4, I am relying upon that the Government of India memorandum my lord, where the age has been increased my lord from 58 years to 60 years my lord.
Yes.
Without taking care of the annexure 4 my lord, the office order has been issued my lord.
Have you served copy on the
It
Uh,
is to go my lord.
ନାଇଁ ତାଙ୍କର ପ୍ୟାନେଲ ଅଛନ୍ତି the Deputy Solicitor General of India.
ମୁଁ ବି overboard ପାଇଁ 3-4ଟା କେସ୍ ବି appear କରୁଛି.
You are-
I also am appearing.
you can appeal in this.
Yes.
So what to do? This office memorandum, this is of 1998, whether it is in force or not.
It is force.
It says that
I have
the
a copy, man.
age of retirement of central government employees is from 58 years to 60 years.
Let's see.
Now, Annexure 3 says, you go through this. I am passing it over, you go through this.
Yes.
So I am solving the copy.
Pass over, pass over.
Yes.
କାରଣ ଯଦି Government of India ର if this notification is there, enhancing the age from 58 to 60, then how come this person will be retired? He's a worker in the rubber board, which is obviously a Government of India undertaking, like it's Ministry of Commerce and Industry. It will apply.
More. I think, my lord, similar type of cases are also pending. And
No,
they have taken a stand, my lord, that is.
Any interim order passed? Yeah, they have taken a stand.
That till that the decision of the Government of India has not been implemented in their society with respect to the employees. But I'm not sure, my lord. I may be permitted to go through this.
I'll do one. I'm passing it over.
Yes.
In the meantime, you can also obtain instruction from over telephone also.
Sir, ମୁଁ କାଲି ଏଇ ରେକର୍ଡଟା ଦେଖି ସାରିଲା ପରେ କଲ୍ ଲିଷ୍ଟରେ ମୁଁ 3 ଥର ତାଙ୍କୁ କଣ୍ଟାକ୍ଟ କରିବା ପାଇଁ ଚେଷ୍ଟା କଲି. The person who was in charge, now he is no more available. He shared me a telephone number, and that telephone number says, my lord, no person, it has not been provided to any person. So
Try
I
to
have
contact again through other means. Through other means, if you
Yes,
can contact.
I'll contact.
Yes.
Beg your pardon, your lordship. One matter your lordship has had on Monday that judgment is reserved in 2nd of April. I have filed a written note of submission to that effect.
Item 13.
You have completed your argument.
Yes, yes.
Oh, yes, ma'am.
The state will not submit, then I will give a reply.
State.
Yes. Not accepting, supporting the impugned order and the findings therein.
Input order is under Annexure 1.
Yes, page 33.
This is that validation,
Yes, sir.
your date of
Joining.
ଦି ଜଣଙ୍କ ଭିତରେ seniority, but my validation.
seniority and
Seniority, inter-se seniority.
inter seniority for the purpose of validation.
But she cannot be, even if accepting her appointment, she cannot be valid.
No, but this is the dispute.
My appointment has to be valid.
What was the final order of the director?
Director has found her to be senior.
Okay.
And my appointment has gone to the 1994 instead of 92. That is the point.
Yes, Mr. Das.
Yes, Lord. That having been the finding, I cannot go beyond that.
So according to you, also the petitioner is junior to the opposite party.
In view of the fact, as has been mentioned in the impugned order at page 33.
33.
However, later on at the second paragraph towards the bottom. However, later on, the services of Srimati Tripathi were regularized from 22nd 1293 to 13/3/95 by governing body resolution dated 8/8/97. But the competent authority governing body consequentially
did not make any alteration and modification against the holding of the post by Sri Mahapatra. If Srimati Tripathi was given her seniority from 22nd/12/93, it is a serious lapse on the part of the governing board. Thus, taking into consideration the pro and cons of the documentary evidence, it is an established fact that Srimati Tripathi is continuing as lecturer in political science with effect from 22nd/12/93 for all purposes. Her date of joining treated as 22nd/12/93. In inter-se seniority among the petitioner and the opposite party number for Sri Mahapatra is determined in the above manner.
Yes. So that is all.
Yes.
Yes, Mr. Das.
Well,
No, this. Why have they challenged it? They have challenged it.
yes. ଆଉ ଥରେ ମୁଁ ରିକାପିଚୁଲେଟ୍ କରିଦଉଛି
ହଁ, କରିଦେବ।
ତାପରେ ମୁଁ ମୋ ସବମିଶନ ଟା କରିବି
କେତେଟା ରିଟ୍ ଆପ୍ଲିକେସନ ଅଛି?
ଟୁ ମାନେ ସିଏ ଚାହୁଁଛନ୍ତି ଅର୍ଡର ଟା ଇମ୍ପ୍ଲିମେଣ୍ଟ କରିବାକୁ
ଠିକ ଅଛି।
That is nothing.
That is consequential.
ଏଇଟା ଗୋଟିଏ ଅଛି
So this writ application has been filed by
me
Saroj Mahapatra.
Mahapatra.
You are Saroj Mahapatra.
Yes,
They are
Anita
Tripathi. Only Tripathi. Okay. Okay. All right.
yes.
Yes. Please begin.
Hello.
ଆମର କିଛି କାଗଜ ଲେଖିଥିଲି ଲେଖିଲି
ମୁଁ ଗୋଟେ ଡେଟ୍ ଚାର୍ଟ ଦେଇଥିଲି ଠିକ ଅଛି ସେଇଟାକୁ ଦେଖିଲେ
ଅଛି
ଇଜି ହବ
ଡେଟ୍ ଚାର୍ଟ ଅଛି କ୍ରୋନୋଲୋଜିକାଲ ଡେଟ୍ ଅଫ ଇଭେଣ୍ଟସ୍
ଆଜ୍ଞା ଆଜ୍ଞା ସେଇଟା ଦେଇଥିଲି ମୁଁ ବହୁତ ଫେକ୍ ଜମ୍ବଲ ଅଫ ଫେକ୍ ମୁଁ ତ କହିଦେଇ ପାରିବି ସବୁ କହିଦେଇଛି ବୋଲି କିନ୍ତୁ ସେଇଥିରେ ଦେଖିଲେ ଟିକେ ଇଜି
ଅଛି କି କିଛି
ମୁଁ ଖାଲି ଓଭରଅଲ କହିଥିଲି
ଆପଣ କୁହନ୍ତୁ ମାନେ ମୁଁ କିଛି ନୋଟ୍ କରିଥିବି ତାଙ୍କର ଇଏ
ତାଙ୍କର ସିଏ ପୁରା ଏଲାବୋରେଟଲି ସବମିଶନ କରିଥିଲେ ମୁଁ ରିପ୍ଲାଇରେ ଦେବି ବୋଲି କହିଦେଇଥିଲି ମୁଁ ଖାଲି
କୁହନ୍ତୁ
ମାଇଲ the present petitioner Saroj Kumar was appointed on 18/12/92 as a lecturer in political science.
18/12/92. Yes.
Yes, ma'am. And I joined on 51/12/92. This appointment was initially on honorary basis.
Your appointment?
Yes, it was on honorary basis. However, in a resolution, because there are financial problem with the governing body, many persons were appointed in such term and condition, along with me also. But then a resolution on 17/7/1993.
Yes.
That I have given is Annex 3. The governing body decided to pay make it a regular salary based post, considered remuneration, and accordingly I have also been paid my salary from the initial date of joining, that is 21/12/1992. The annexure 2 page 35 is my appointment order. In this regard, if my lord want to see, can have a glance.
Yes.
Page 35. Saroj Kumar Mahapatra, appointment lecturer in political science. The governing body of the college have been pleased to appoint you as a lecturer in Department of Political Science on honorary basis, considering this and now this resolution is page 36.
Yes.
This was duly attested and given to me. This is because now later on their argument will be this was not. Director's finding is very peculiar, I will say. He has dishonored all the documents. Only accepted how the peculiarity is, I would say. All these documents I have filed before him. He has not considered none of the document I have filed. So that is, this is a resolution, my lord. And kindly see, my lord, towards middle, item number 6. Agenda to put it. Considering the representation of the following honorary lecturers in the Department of Physics, English, Political Science, Commerce, Sociology, Public Administration regarding their monthly payment, meeting to be discussed and financial position of the college and announced resolved to pay consulted amount of 600 per month as a remuneration to each of them. My lord, my name is serial number 3, Saroj Kumar Mahapatra, lecturer political science, 21/12/92. So I got my salary. To skip over this thing, my lord, to justify these facts, because this is a bearing the in consequence in the due course of my continuance. Provident Fund Authority have also, this enforcement officer also come to the institution to assess the staff position and they have also assessed all the records of the institution
and found me to be a genuine employee. From this date, they verified the pay equivalence rule, and accordingly, assessment was 7A proceeding was instituted, penalty was imposed on the management, and they have also paid the dues, the EPF dues in my favor to the authority. Till date, it is continuing. So, in these peculiar fact and circumstances, and that order of the EPF Commission was also challenged by the governing body in appeal before this honorable dismissal, and thereafter appeal they also lost. So that means the finding of the 7A order is in my favor, that yes, I am an employee from this 21/12/1992. So none of the other record of the institution says anything contrary to me. So accordingly, I filed a case because 21/12/92 appointee can be validated under the Lectures Validation Act 1998. It says, my lord, the appointee between 1/1/85 to 31/12/1992 are coming under the Purview of Validation Act. If they are appointed against a admissible post, because there are two type of posts in the institution. One is approved post, another is admissible post. Approved post, my lord, suppose somebody is appointed and that is approved and paid granted, that is an approved post. But if the workload justified, because the workload calculated like this, prior to 1994, it was 21 classes per week. Good subject 21 class to the week rehla, tahle hochi 21 plus egale, second post lecture as 22 class hele, 2 lecture rehbe, 21 hele, 1 lecture rehbe. Likewise, my lord. So I was to be appointed, and because it is a big college, the workload justified my appointment, and it was verified, recommended to the government for validation under this Lectures Validation Act. Shall I read? Oh, that is, yes. So, after proper verification, director come to a conclusion that yes, my appointment is to be validated, along with another person. 3-4% recommendation was made. That order of the director recommending my name for validation, and it was in the verge of approval under the Validation Act, and I am to get the granted from 17/10/98 as per the provision of that act, because that act says even if you are appointed, your salary will be from 17/10/19. That is the law. So that particular order was challenged before this honorable court by this Anita Tripathi, opposite part of 4, in a writ petition. And in the writ petition, her entire claim was, I was never appointed on 21/12/1992. Rather, she was appointed on 13/3/1993, and thereby she is senior and a junior. I was appointed in 1994, and therefore she cannot be ignored. And that order was set aside. Matter was remitted back to the director. So what other fact is, my lord, this governing body in 1994 issued an advertisement, because initially it was all these are temporary appointments. They say all the employees will face an interview. And in fact, interview for same post to regularize all these things. They have asked us to join. That is why this regulation order. In 1994, they had asked, advertisement was issued, recruitment was made, and I, along with this Anita Tripathi, as an outsider by then, she was not there in the institution. She also joined. Appeared the interview, and we both were selected in the interview because I was appointed on that. My service was just regularized. That is why a resolution was also passed in the resolution number 40. A resolution was passed declaring me senior to her because she joined in 1995. That is 94. 94. And I was continuing from 1992. Therefore, the matter was, she joined, a portion to that selection model, she joined on 4/3/95. Yes. 26/12 appointment order. Actually, 19/12/94 was the appointment, and she joined on, but I have not submitted any joining report. I was just regularized. So this was continuing. This was the fact. So when the matter remitted back to the director at the instance of this honorable court, so matter was heard, and the final this order was before the director. She was appointed on 14/3/1993. Appointment 14/3 joined. He was her claim is 14,393 she joined and thereby, and I joined in 1994. Because of that next election, she has recapitulated. She has not stated anything about, suppress the fact with regard to her joining on actually 14,395 pursuant to that appointment order. There is a selection. Her application also I have given it. I'll take my lords to that document. And more interestingly, my respect submission before the Honorable Court and as well as before the director, the same document, whatever I have filed it here. My case in nutshell was, this person has suppressed the material fact with regard to her appearance in the selection, her own application to the job in 1994, and the manipulation with regard to, in connivance with these governing body members or the principal, how the manipulation is done, that is telltale from the face of record. No need to say that this is a disputed fact. This is on the record. The appointment order she shows, that 93 appointment order, what she shows in her favor, that is a fraudulent document because the letter number is of date. Letter number was issued to the director. Same letter number, a letter, genuine letter was issued to the director with regard to payment of gratuity of some employees. But by manipulation, she says that this is my appointment order. That both the document I have given. The other part is, he says, I was appointed initially on same principle. What we have now, we are saying that we are on. He says, initially I was honorary basis, and subsequently I have been paid the salary. But the fact remains from the record. Exact amount what he is to get for that period, particular calculation, she has donated to the institution and it has been paid to her. The same date in the overwriting the cash book and other thing. But very aspect of the matter, the forgery they have slipped, I think. If any donation is given to the institution or even payment is to be made to the staff, then it has to be in the cash book or in the audit report. But the audit report for the entire period never discloses any donation, the amount she has given on the particular date. Those are the records I want to show, madam. So kindly see. But the director, ignoring all this aspect, that given her the appointment. Now, my lord, kindly turn to page 37 first with regard to my receipt of my salary. That after that annexure 3 resolution, the payment was made to me along with other staff member in the pay acquittance rule. Page 37.
You have seen it?
Yes, sir. And in 1998, because she has made some complaint, the governing resolution, kindly see my lord, resolution page 39. This is an important resolution.
Yes.
Meeting number 40, dated 27/3/1998. Item number 3. The principal cum secretary put forth the representation of Saroj Kumar Mahapatra, lecturer in political science, Tapan Kumar Naik, lecturer in commerce, Mrityunjay Narayan Das, lecturer in public administration, Miss Monica Naik, lecturer in sociology, this college regarding the regulation of their honorary period of service, that is from 21/12/92 to 28/12/1994 of Sri Saroj Kumar Mahapatra, 21/12/92 to Etiki of Sri Tapan Kumar Naik, so and so. The meeting today briefly felt its genuineness and unanimously decided that their date of joining will be treated as 21/12/92 instead of 29/12/94 of Saroj Kumar Mahapatra, and instead of Sri Tapan Kumar Mahapatra, so and so, Miss Monica Mahapatra.
According to them, this is a manufactured document. According to them.
This is a genuine document. That is why I have also filed. This is the resolution. This resolution number 30 and 40 is disputing.
39 na?
No, এটা 40 সেটা পেজ 39
আচ্ছা
এটা পেজ 49 মিটিংটা হচ্ছে 40 this resolution of 40 and this page 36 annexure 2/3 resolution number 30 he is saying these are the manipulated documents. Resolution is not there, but I have filed. These are the resolution I have filed before the director. I filed it because this allegation was made. I have also filed the document at page melon. The source I have got it. The members of the governing body have also handed over the same document to me, and I have filed it again in this honorable court. ଏତେ volume says the page. Yes, madam. The document, these two documents, I have again filed the document supplied by the, because all the resolutions were circulated among the members of the governing body. And I have collected this from the members of the governing body who is with a affidavit, they have given it to me, and I have also proved that, yes, these are the genuine documents.
But I think apart from this case, academically, there is probably a provision by which the district education officer or the inspector of schools, as he was then.
Yes.
The resolution book is required to be signed by him at the end of the year or something like that.
Yes, no, what actually rule is nobody doing that. The rule says each of the resolution after approval of the president is to be communicated to the authority council.
Each one
resolution.
ସେ ବହିଟା ପୁରା ସାଇନ୍ ହୁଏ ନା କଣ?
ବହିଟା ଯେତେବେଳେ ହଉଛି ଇଏ ହୁଏ ସେଟା ସବୁ ଆଟେଷ୍ଟେସନ କରନ୍ତି ସେମାନେ ଆସେ ଯେତେବେଳେ enquiry ବେଳେ all the resolution book has been signed.
Because that will take care of this allegation of these
fraud and
manipulation.
Yes, that could happen.
Anyway, continue please.
Everything has to be communicated. ଏତେଗୁଡ଼ା document ଗଲେ ଡାଇରେକ୍ଟର ଜାଗା ରହିବନି ସବୁ କଲେଜ resolution ରଖିବା ପାଇଁ. So now these resolutions I have proved that these are the genuine documents. What else she has argued against me, I am just placing first, thereafter I will tell against her. She says, this petitioner along with some other person, they have filed a case in this Hon'Ble Court in 99.
Yes.
OJC number 6101 of 1999. 6101 of 99. And I was the petition number 17 in that case.
Yes.
And there I have stated my appointment is 1994, not 1992. This is one of the allegation, my lord, and the writ petition copy they have filed. My specific argument is that, my lord, the deponent in that affidavit in that particular case was one Govind Chandra Swain. And we have signed the Phoklatnama, but we have not ever given him any documents to file this case. But when we came to know that there is such a case has been filed, and our names are there with distorted documents, not the correct documents or correct facts of the petitioner. So immediately we have instructed him go and withdraw the case, and in fact the case was withdrawn. So my response submission is, so since the case was withdrawn on our instruction because there is incorrect facts in the writ petition and there was no order adverse to the parties, such a petition cannot be in way, cannot come in our way to get the benefit what we want to get it in view of my original appointment dated 21/12. Moreover, when the facts have been further clarified in different forums with regard to that EPF, because EPF is also a proceeding, is a court proceeding, and it has been carried to this Hon'Ble Court, again appeal, all these things, my lord, that documents, everything is there, and we have given it. And in that particular EPF proceeding, because it was for all the employees, because that enforcement officer do that job. There, my lord, the Anita's appointment was in 1995. It was never 1992. The notice was given to her. She chose to accept that. That notice also I have given it here. She didn't reply or objected to that order.
Anita's appointment कैसे?
Anita's
sorry. EPF document.
EPF document रहुची 14/3/95. That was the assessment also made accordingly. She never raised any objection that no, it is 99, not 1995, it should be 1993. She कहूँ 14/3/93 तांकर. So she could have raised objection there also. She didn't raise any objection. So assessment was passed on. Payment was made by the institution. That means her appointment was accepted to 95, not 1993. What he is objecting is my appointment in 1992 is wrong. Her appointment in 14/3/93 is correct. That is why she is senior to me. According to her, I joined after that interview in 1994, 21/12/1994, not 92. And all these are fraudulent documents. But my response submission is, all these documents, what I am submitting, that my appointment is 1992. Initially, rightly, it was on an honorary basis, but it was salary was paid to me. It was regularized in 2 resolutions of the governing body. And that is why I am continuing from that particular date, 21/12/1992. And I am to get the benefit of the valuation act. And since your own admission is 14/3/93, let us assume for the moment you are appointed in 93. How will be senior to me? I am in 92, you are in 93. definitely you are junior to me. If this only this EPF documents and other verification record resolution will be ignored only, then my appointment will go to 1994. But in that way also, I am 1992. So therefore, I am senior to her. That is why the governing body has decided, by taking these facts, I am senior to her. And this resolution was never challenged. Because as per the law, the Sashikanta Mishra's case, this Hon'Ble Court has decided interest seniority between employees is to be decided by the governing body, not by the director.
This, what I'm going to say may not be very relevant, but he has raised another point that the EPF Act was made applicable and subsequently it was withdrawn.
No. EPF, still I am in EPF.
I don't. Anyway, that is his submission.
I am filing in memo. Kindly have a glance. I can take into record. This is the, I am filing in a memo. Till date, EPF is, because.
Give a copy to them.
I just see.
কিন্তু আচ্ছা খালি মানে প্রথম হিয়ারিং পূর্ব লিখে দিতে Samir Kumar Das, then counsel for the petitioner files copies of payment receipts of EPF contribution of employees. It can be kept on record. That's
right.
One.
So this is not, it is 24 I am giving. The receipt is 15/4/24 with the latest date. EPF deposit huge. What he is saying, it is not correct.
Anyway, take
it. So this is the factual. And all these things, all this not for the purpose of this order annexure 1, these are not relevant because this is a case of 2009. This writ petition is 2009. So all these things are subsequent. Whatever he want to say is all the document he has created further. Now in additional affidavit, further affidavit, everything is filed. This is virtually a cessation proceeding. Whatever it was before the director, that on the basis of that it is to be decided. And therefore, it is quite a voluminous brief. Otherwise, the issue is very limited. Whether my appointment is 21/12/92, whether her appointment is 14/3/93, or
that's all right. But having heard now, I think let us go to the impugned order now.
Yes, yes.
What is the finding? That will, I think.
Yes, before that, before going to the impugned order, I will show the illegality committed by her. Because what I have submitted, I have stated against me and my favor. Whatever the record is, I have not shown the record. Kindly see the her appointment order. Kindly turn to page 42. She is claiming 14/3/93, my lord.
Yes.
Correct, there is no dispute. Now kindly turn to page 42. One of the document, annexure 6. I am just reading out. This is an application of Anita Tripathi dated 26/12/1994. What is her application? To the principal BMA College Palyabindha, subject application for post of lecturer in political science. Respected sir, as I came to know your minute from newspaper Rashtraduta dated 20/12/1994 to give appointment a lecturer in political science. I offer my candidature for the same post. I request you to accept my application for your kind consideration. Detail of my biodata furnished below. This is the biodata. Anita Tripathi, father's name, address, permanent address. So this is an application. And her qualification, everything she has given next page. Nowhere stated that, even if, let us say, she could have filled it here, that yes, I am continuing your office, but I am applying. It is not his case. It's a fresher. On 26/12/1994, you are a fresher. Then where from you got the appointment order 14/3/1993? And moreover, when if you are continuing since 93, what is the requirement to apply for? This is my submission first. Now, these are the records I have produced. The director has not given any finding to that. So this is the second appointment order, as 7, page 44. Anita Tripathi, so and so, you are hereby selected, selection committee 27/12/94. Hence, the management has been pleased to appoint you as a lecturer in political science, 5th post. This is our document. 4/3/95, the appointment order was issued, and she was against the 5th post. She is not questioning this appointment order. She is 5th. I was holding the 4th post. That is why I am senior. And she, in pursuant to this appointment order, my lord, she has submitted a joint report also. That is annexure 8. With due respect, I submitted my joint report, lecture of political science, today, 14/3/93/95. So this has joined and against the fifth court.
Yes.
Accepted position. Now what she want to say is uh, hundred three. Yes, just no, over. Well, kindly come to page 194. CS5. The appointment
Yes.
order.
Yes.
Annexer S by 4, page 100, internal page 51 of our counter. Running page probably is 194 if it matches with my notes.
Yes, yes.
This is BNM College Payabindha. Office order number 870-19-12-93. This is important. Can I take it? Office order number 870. Where got it?
I've got it, but this is 93 ki 94 figure.
93 ଜଣା ପଡୁଛି ବୋଧେ ଏଇଟା ଅଛି ଟିକେ ଦେଖିଲେ ଏଇଟା ଅଛି 93
ଠିକ ଅଛି
ଦେଖା ଯାଉଛି ମୋ ପାଖରେ ଯୋଉଟା କପି ଦେଇଛନ୍ତି ଦେଖା ଯାଉଛି
ଠିକ ଅଛି
19/93 ଉପରେ ଲେଖା ହେଇଛି ଅଫିସ ଅର୍ଡର ନମ୍ବର
yes
dated 19/93
yes
Miss Anita Tripathi ad hoc appointment lecturer political science. This is the appointment order filed by her 19/93. Now kindly take note of this page. Now kindly come to page 95. Here the consolidated sorry my lord, I could not read it. Management of the college given to please to appoint you as a lecturer in political science with a consolidated salary of 600 per month. This is the order. Letter number is 870. Now kindly come to page 95.
Yes.
This letter appointment order is 19/93, office order number 870, and all the office number are to be placed in a year in a seriatim. So it is 870 on 19/93. Now kindly come to page 95. So letter number 869, office order number. It is also office order number.
Yes.
Page 95. Office order number of the principal dated 20/93. 20/93 letter number टा होची 869. ताकू appointment 870 टा होची 19/12. And this letter is addressed the salary of the following teaching and non-teaching staff are withheld on the date for the reason stated against the name.
Yes, yes.
This is a letter of the principal to the director with regard to through the assistant director.
The order number is earlier than the
No, 870 भी ସେଥିରେ ଅଛି ତ memo ଟା ଦେଖୁ memo ରେ 870 ବି ଅଛି memo number 870 is addressed to the assistant director DP direct payment office of the director. Same number in a later date, that is 20, has been 20/12/93 has been issued actually to the director with regard to these 5 employees regarding the payment and non-payment of direct payment. So this is a document of the college. So my responsibility at the outset, the so-called appointment she is now relying upon in annexure S/4 to the appointment order and before the director 19/12/1993 is proved to be a forged document. I would say, with due respect. This is a forged document. This manipulation part I have, though I have filed all these documents, director has not given a single finding with regard to this. So therefore, on that ground also the order of the director is to be set aside, besides all other points. Now, my lord.
yes.
There is a letter of the principal, next page, my lord, page 96. These 5 pages also. This is a letter of the principal. Consequent of decision of the governing body BNM College Payabindha in meeting date number 38/8/97, item number 8, ad hoc period of service of Anita Tripathi, election political science, with effect from 23/12/93 to 13/3/95 has been regularized. In view of the above fact, she is entitled to draw her consolidated salary of rupees 600 per month with effect from 22/12/93 to 13/3/95. This is done in regard to her regularization of ad hoc period of service and other conditions. Henceforth, her date of joining should be treated as 22/12/93 instead of 14/3/95. This is an order only on 34/99, and this is also another fraud. For the reason, there what they say, want to say, your appointment of 19/12/93 is regularized because pursuant to this page 194, that appointment I have shown, my lord, you are regularized only in 99, and the subsequent appointment 13/3/95 jo joining that particular period 93 to 95 has been regularized. And one peculiar aspect of the matter, they want to say now you are paying you 600 rupees salary in this resolution. What is the requirement? If he is appointed in 93 with a consolidated remuneration, whatever may be 1 rupees, 2 rupees, he is supposed to get it every month. Only on regularization he will get the salary. That was not the condition of their service. But on the contrary, if you now reconcile, our appointment or my appointment was in honorarium basis because there was a positive fund. Now, when they acquired some fund, they want to give it from the date, and that becomes 600 or 300, what is, and in 1 lakh it has been paid. But here, when your appointment is in a particular scale, whatever it is, you are supposed to get it every month. You could have waited from 93 to 99 to get your salary only on regularization. This type of thing is unknown to the law. So this is another limb of manipulation by these college authorities in her favor. And further, now my lord, kindly see the page 98, how she has been paid. The manipulation in the cash book, evidence book. Kindly see, my lord. Already something, 2 names have been, serial number 1 and 2 has been written. Something else was written which is scored through. Now there was a signature of the principal, there is a seal. But on the very signature, after the, how it has been manipulated, kindly see. It would end, 21/93 heading name तळକୁ सर देखा होची 21/93 लिखा होची ता तळे 21/93 दस्खत करचंती प्रिंसिपल टिके सील एंड सिग्नेचर 21/93 किंतु ता ऊपर पटिक लिखा हैला 22/94 माने जदी 21 टा कंप्लीट हैला प्रिंसिपल दस्खत करबे सेठी जे अथॉरिटी तो दस्खत तळକୁ जदी लिखा हुआ तळକୁ लिखा हो नेक्स्ट डेट ना या ऊपर चढ़ी देले सब कारण आ जागा नथिला एबो कोन लिखा 22/94 अनिता त्रिपाठी नाटा ताको दस्खत ऊपर पे हैला 650 पहली मार्क अपॉइंटमेंट ऑर्डर रेगुलेशन ऑर्डर हैला 600 so how could she be paid 650 and the total amount this is another limb of and kindly see my lord तार continuation let the D page रे जेहेतु आ गुटे पेज कोटा एक्सटेंड हिची तार नेक्स्ट पेज ता आ गुटे लंबा का दी पेज जे अनिता त्रिपाठी पीरियड क्लेम 22/93 13/3/95 एठी किंतु पुनी सीरियल हे गेला पेज कला 600 8846 अनिता त्रिपाठी दस्खत कर पैसा नेले 8846 तंग दिया इनेस पेमेंट था एटी 650 तब 846 then kindly come to the audit report page 101 ISO 23 is the following letter
ସେଥିରେ ନା ନାହିଁ
ନା ଏଥିରେ କହିଲି ଆଉ ଥରେ ମୁଁ ଖାଲି ଦେଖୁ ସେଟା पेमेंट टा देले से माने एठी गुटे दस्खत अछि एठी तळे से जो पेज 99 को आउथ सर सॉरी से जो पेमेंट तळे गुटे प्रिंसिपल को सिग्नेचर अछि मे 99 रे ए जो 8846 टा देले से ता नेक्स्ट पेज रे 100 पेज 100 रे 1/5/99 से देले नेले से 1/5 नेक्स्ट 100 पेज रे 22 रे 1/5/99 गुटे स्लिप अछि मिसलेनियस रिसीप्ट 8 8,843 received from A Tripathi, so and so. Towards donation.
8,846
Yes.
43 no.
Again?
43 no, 46
46. It is 46, bro.
नहीं अपन 43 कहले
Oh, sorry, my that is slip up. 46. Purva page, 99 page, 100 page, 8,846. Equal amount she has received, and this, on the very same date she has donated. It will call a donation. It is 99. Kindly take note of.
Yes.
If there is a donation, my lord, everything will be come in the audit report. Now I kindly see the audit report of 99 2000. It's a payment in 99. So it is within that year 99 2000. Kindly see the audit report, page 102.
Yes.
This is the audit report. Kindly see, my lord, next page, 103. Donation towards middle. Other grant and other thing towards middle donation.
It is not mentioned.
एटी किछि नहीं से वर्ष रे कोनोसी डोनेशन नहीं जदि 8,846 टका अनित रिपोर्ट दिउ जे भी दो से वर्ष रे आदो डोनेशन नहीं
बोला चलो
fine. So therefore my submission is if you have donated that would have been placed in the audit report and you have taken your salary that would have been also reflected, so the balance may be zero but it should have been, but because it is manipulation, audit has been completed by that time, so now they are manipulating record by forging the college record, office order number, and now preparing the donation and all these things to show that she has also been paid.
You had actually pointed it out on the previous occasion.
Yes, document yes, these are the points, my lord, because with regard to her, because what she says 14,393 is my date of appointment, not 14,395. But 14,395 now from the record, 14,395 has been proved that yes, she was appointed in 14,393 by making an application, appearing to an interview.
No,
but it has been manipulated to show in 93.
I would like to know
could have been shown in 92 also because she has passed in 93 MA. So she could not. She could have shown much earlier because if she could have passed the MA also.
I would like to know how the director has dealt with all this.
Yes, madam. So these are the manipulation. Other thing what he has said is, well, against me argument, page 104. He says, I have not, at the time of appointment 92, I didn't have the 54%.
Yes.
That document I have given it. Kindly see, my lord. Page 104 is the provisional certificate.
Page 104.
104. Annexure 24.
Yes.
This is my provisional certificate, MA Political Science, 1992. Again?
Percentage to 9.
Yes, what's the page? Mark page 105. 421. 52.6%.
से केते थिला कि
सेतोले थिला 48 91 रु 97 पर्यंत 48%.
तापर 55 बेला
54 मोर अछि तापर मु एनहांस करछि फोन काली सीमर एटा होछि जुलाई रे परीक्षा देली 90 रे परीक्षा रिजल्ट वाला 441 ने 21 सॉरी नेक्स्ट पेज में पेज 106 I have appeared the repeat examination. I have secured 5441. That is 55.1%. I have also enhanced my percentage by repeat examination. So it is not a fact. This is also incorrect fact that I didn't have the qualification on the date of appointment. I have already enhanced my mark and I have secured 55.1%, which is the required percentage. So these are the documents I have given in my support. And one more thing, well, because I am going by the serial this document because that will be argument of him. Page 107. What he says is one of his submission. At the time of appointment, that Dr. Ananta Chandra Das was not the principal. Therefore, my appointment order of 1992 is a fraudulent document. But kindly see the college calendar. Successor list of the principal. Page 107.
Yes.
Serial number 14. This is the incumbency chart, my lord. Dr. Ananta Chandra Das, he was the principal 8/12/92 to 22/8/94. Got it? Yes. So therefore, my appointment order was issued on 18/12. He was on 8/12. So after his joining, he has issued an appointment order. It is not a fact that he was not the principal. That is also one of the allegations against my appointment order of 1992. He says this is a fraudulent document. The principal, Ananta Das was not the principal. How could he issue an appointment order in his paper? And to that effect, well, very surprisingly, the subsequent principals, another principal who has done all these things on our behalf, she has given a document also that is filed by her. Ananta Das was not there, then this appointment is false. This certificate is also, and these facts were accepted by the director. Very unfortunate affairs. These are the documents I have filed. And
how much more time will you take, Mr. Das?
well, because I have to solve this thing. Because
I have taken all note of all it.
I would say
I was thinking of we'll continue next week.
Again.
We'll continue next week. Other matters are there, that is why.
Oh, yes, I will come so much.
15 minutes more. Next week.
Again.
You will only, I have taken note. Whatever he has said, I have taken.
Yes.
And I have also taken note of whatever you have said.
Yes.
Now, what we will do is we will come to the impugned order.
Yes, I will read it, complete it with the other. I'll see if you have taken it.
ଆପଣଙ୍କର ଆଉ କିଛି ନାହିଁ
ଏ ଯୋଉ ବହୁତ ଲମ୍ବି ଆର୍ଗୁମେଣ୍ଟ ପାଇଁ ଲର୍ଣ୍ଣ ଶୂନ୍ୟ
ଆପଣ ସର୍ଟ କରୁଥିଲେ କି
ତମେ କଣ କରୁଛ
ଆପଣ ସର୍ଟ କରୁଥିଲେ କି
ତମେ ଦେଇ ସାରିଛ
15 ରୁ 20 ମିନିଟ୍ ଭିତରେ କରିଦେବା ପାଇଁ
ମୋ ପାଇଁ 15 ମିନିଟ୍ ତମ ପାଇଁ ଦିନ ଦେଖୁଛନ୍ତି ମୁଁ ଆଉ 5 ମିନିଟ୍ କରିବି
ଆମେ 5-10 ମିନିଟ୍
ଆଉ କହି ନବୁ
କାହାକୁ this court will grant you opportunity equal to all. The order may go may go in your favor, it may go against you, depending on the understanding of the court. But opportunity of hearing will be definitely granted.
That item 16, I have another matter in the list today.
Aji.
ହଁ ଅଛି ସେଟା ଗୋଟେ ସେଟା ଗୋଟେ ଏଫଏ ଗୋଟେ ଫାଇଲ ହେଇଥିଲା ତାର ଅର୍ଡର ମଡିଫିକେସନ ପାଇଁ ଫାଇଲ କରିଛି ସେଟା ଲିଷ୍ଟ ହେଇନି ଟିକେ can it be 1 week after ମାନେ
Item 16.
ଆଜ୍ଞା
Who is the other side?
ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଅନ୍ ଟାଇମ୍ ନଥିଲା ସେଟା ଗୋଟେ ପଏଣ୍ଟ ହେଇଥିଲା ମୁଁ ତାର ମଡିଫିକେସନ ଦେଇଛି
As requested, list this matter on
1 week after
12 July.
ଆଜ୍ଞା
It has item 16 ହେଲା ଆରଟା ଲେଖନ୍ତେ ଏଇ ଯୋଉଟା argument ଥିଲା heard further arguments. List this matter next week ନବା next Friday. Next Friday କେତେ ତାରିଖ ହଉଛି 5th July. All right.
Tuesday Friday ଟା ଆମର ସେ ଏଫଏ ଚିଫ ଜଷ୍ଟିସ କୋର୍ଟ ଶହେଟା କଣ୍ଟେଣ୍ଟ ଟିକେ ଅସୁବିଧା ହେଇଯାଉଛି
ଆମର କୋଉ ଦିନ ଫାଙ୍କା ଥିବ ଦେଖିକି କର
ଅଳ୍ପ ସମୟ
ନା ଅନ୍ୟ ପାଠ ସବୁଦିନ ପାଠ
ଶୁକ୍ରବାର 4 ତାରିଖକୁ ଆଜ୍ଞା ଆଜ୍ଞା ହଁ
4 July କରିଦିଅ
ଆଜ୍ଞା ଏଇ ଯୋଉ ଚାଲିଛି
Yes, item 14.
14.
Mr. Rata ଖାଲି କହିଥିଲି କ୍ଲୋଜ କରିବି ବୋଲି ଆପଣ ଯାହା କହିବା କଥା କହିବେ
I've got the instruction middle.
Very good.
Instruction middle.
ଦେଇ ତ ଦେବେ ଏତେ କଥା କଣ
I place it. I want to place it the instruction middle.
Please, please. I'm not stopping you. Please.
I'm serving the copy to all segment.
Since there was a judicial order directing you to obtain instruction, that is why I had adjourned it.
Yes, ma'am.
କଣ ହେଇଛି କଣ ଏଥିରେ କହିଛନ୍ତି ଏତେ କଥା କିଏ ପଢିବ କୁହନ୍ତୁ କଣ ହେଇଛି
କଥା କହିଛି କେବଳ ଆପ୍ରୁଭାଲ ଟା ରିକ୍ୱାର୍ଡ ବୋଲି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ର ଯାହା ପରବର୍ତ୍ତୀ ଡେଭଲପମେଣ୍ଟ ରହିଛି ଇନ୍ ଏନି କେସ୍ ଆପ୍ରୁଭାଲ ଅଫ ଦି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଇଜ ରିକ୍ୱାର୍ଡ.
Yes, then I will direct the government to approve.
Yes.
How come? What is essentially what is your stand here, Mr. Rathod?
Yes, I am placing it.
ମାନେ stand ଟା କଣ? Government କହିଲେ ଯେ university is competent to take its decision. Government କହିଛନ୍ତି ତାଙ୍କ counter ରେ
ସେଟା ତ ସେ କଥା କହିଛନ୍ତି. Besides that, the documents we have filed, Miller, in this instruction, Miller, the government has categorically stated that the approval and the finance department, the prior permission of the finance department is required. So therefore, in any case, since it is a grantinary institution, your lordship knows, all the posts are created of it is approval is necessary.
So how best to get out of this imbroglio?
The instruction is very clear, Miller.
The instruction is clear, Mr. Arthur, but their counter is also in their counter. Let us come to that.
That counter I have seen, Miller. The one point they say, what the point?
The university is taken.
We have sent proposal to the government for approval of the. He rejected all the time. He rejected saying that yes, court has not directed to give regular appointment, and other stands they have taken in different states. So in that even the government could have said that it is autonomous, since you were an autonomous institution, you could have created
the manner to call the The matter related to creation, abolition of posts and appointed made under OET establishment is within the purview of the university as it is an autonomous body. So if it is a question of appointment, if the university decides, then the formal approval is to be granted by
Yes,
the finance department.
yes.
Kitchen, I will issue my number.
Sir, that is what I.
Or may I pray your lordship fix a time duration for a final outcome from the government,
No,
hearing all the parties.
all right, but this is a case of the year 2011.
Yes.
So this is like a ping pong ball. The petitioner is being asked to move from the university to the
Time
government.
period, your lordship will fix.
No, I will issue my numbers. Upon challenge kariyo karan. No.
Your lordship.
Heard arguments in full. Judgment reserved.
Instruction will be kept in record.
Agal Lakhondu, counsel for the university files copies of the written instructions and some documents. Do we serve copy?
Yes.
After serving copy on the other side.
Yes.
Stop. Same be kept on record. Heard further arguments. Judgment reserved.
Yes, ma'am. Right.
Item 15.
इतना note for किसी दरकार.
Right.
Item 15.
मोस्टली पीके महंत पीके महापत्र ऐसे आर के महापत्र में लिखा है
आगे
से जो पॉज लिस्ट आसी से एक्सपायर कर जाइछन तापर मु अपियर करछि
You are Mr. PK Mahapatra.
नहीं नहीं वो पीके महांत प्रशांत कुमार महांत
अच्छी तो.
हां आगे वो ना अछि महापत्र जी एक्सपायर कर दे
PK Mahapatra. है ना? Petition वाले PK Mahapatra.
Item 15.
I'm for the OP6 measure.
You know, then counsel for the petitioner is absent. Counsel for the opposite party is present. List this matter next week.
Item 17.
Before I take my lords to the merits involved here, I request my lords to see order dated 15/2/2023 and the last order passed, then I'll appeal.
15/2/2023.
23.
As per notification, the fifth preference candidates were required to appear physically on the along with all original seats. Only 8 candidates appeared on the fixed. On the date fixed, among whom the petitioner was placed at serial number 4 in view of the marks of the candidate.
Then the last order passed my lords.
Last order is
এটা কো
কেবে?
দেখিলো না
25
25 ଥରେ ଥରେ ଟାଇମ ନେଇଥିଲେ ତାପରେ 7/5
ହଁ ସେ ଟାଇମ ନେଇଯାଇଛି. Yes.
ନେଇଥିଲେ ତାପରେ 7/5 ଆପଣ ସ୍ପେସିଫିକ ଲେଖିଲେ ଯଦି ନଦେଲେ ମେରିଟ ରେ ଯାହା ଅଛି ଶୁଣିବେ.
Yes. ଶୁଣିଦେବ?
There is no further affidavit from outside.
No, that instruction you have not obtained?
No.
କଣ କରିବା?
Your lordship had said that on the basis of materials it will be decided as your lordship would please.
Yes, what do you say? Mr. Ratha?
Okay.
What do you say?
But I am
If there are vacancies available and this person was placed at serial number 4. 4 na?
Okay.
Huh. 8 candidates had appeared on the date fixed, among whom the petitioner was placed at serial number 4, as per the marks obtained by him.
yes, madam. And interestingly, those who are
And
not,
this has not been disputed by you in your counter affidavit.
Now, in the counter affidavit in paragraph 7, there is a specific assertion about the lesser percentage of the petitioner than those who were enlisted for the 5 vacancies.
that is the point your lordship wanted instruction, because those persons, they have never appeared before the selection committee. How could they be engaged? That is the reason your lordship wanted specific instruction as to their attendance with reference to the records.
No, here instruction will be necessary. Because how can the court
In
decide
fact,
then?
the very day I had telephoned them and had written a letter,
କିଛି ନାହିଁ ଡାକି ଦିଅନ୍ତୁ ଆସନ୍ତୁ. ଆସନ୍ତୁ. Who is to give the instruction?
next week ଗୋଟିଏ chance
ଏତେ ଲିବର୍ଟି ଦେଲା ବେଳକୁ ଆଜ୍ଞା
ନାଇଁ ଆଉ ଗୋଟେ ହେଲା
ଭାବିବେ ଯେ କୋର୍ଟର ଦାନ୍ତ ନାହିଁ ବୋଲି.
ନାଇଁ that they won't dare.
ଆଉ ଗୋଟେ ଚାନ୍ସ ଦେଇକି ତାପରେ ଦେଖ.
Shri R. Das Leonard AGA requests for adjournment on the ground that despite requests, he has not received the instruction as yet. So, this court finds that the query posed by the court is required to be answered for a just decision of the case. Therefore, as a matter of last chance, the matter is adjourned to next week.
Sir.
It is made clear. Who is to submit the instruction?
In fact, the counter was shown to
the director.
yes.
Yes, Mr. Rathar.
The director project coordinator DPC 4 number वाला असले का OP number 4 district project coordinator.
OP number 4 had shown the affidavit. I'm sorry. Yes. District project
Is this
coordinator.
matter on the instruction sought for be furnished, telling which the opposite party number 4 shall appear in person before this court and file an affidavit. That's all. Next week, yes.
Would your lordship further specify that he will come with the records with regard to attendance of those appointed persons?
That query to see order order clear.
Okay, so great. Sir, तारीख होची
Next week.
Sir, आपण appearance कथा lecture तो ଗୋଟେ date टाइगर.
Date है ना?
5th July.
Copy of your lordship.
Yes.
First submitted item 12.
But in fact, my lord, I could not contact them, my lord.
I'm sorry. In the earlier case, a copy of your lordship's order.
Copy of this, a free copy of this order be handed over to the State Council for complaint.
This is a matter relating to enhancement of the retirement age matter. The status of the petitioner as it reveals from the impugned order itself that he is a worker.
Worker ହେଲେ କଣ distinction ଅଛି?
ସେମାନଙ୍କର status ରେ ବୋଧେ ସେମାନେ ନିଆ ହେଇନି. But I'm not sure, my lord.
So how
will lordship will take up the matter, my lord, next week, then I can.
Take it up on Monday?
Take it on Monday.
Monday, then my lord, on 30th Sunday, the petitioner will retire.
କଣ କରାଯାଇ ପାରିବ କୋନ?
I will pray, my lord, let the petition to continue.
Lordship may observe that by the next date, my lord, if any response will not be filed, then his previous position will be restored. If I can succeed, my lord, to establish that no, he is not entitled, then he is not to get it.
I'll call it on Monday.
Lordship may call it.
I'll call it on Monday.
Yes.
So Monday hele continuation order can be passed.
Yes, yes, madam. That will be better. Yes, madam. On Monday.
It is submitted that the petitioner is due to retire on 30th June 2024.
Yes.
30th June, 30th of this month. Sriasan Patnaik, Learned Counsel appearing for the rubber board.
1, 2, and 4.
Secretary opposite, all the opposite parties.
Nah,
opposite parties 1, 2, and 4.
Central government then.
Request for
3 times is the rubber road.
time to obtain instruction
Institute.
as regards the applicability of the central government notification to the central government notification relating to enhancement of the retirement age to workers like the petitioner. Stop. List this matter on Monday. Monday? Order on the IA shall be passed depending on the instruction obtained by the Sri Patnaik. So that on that day
there will be a continuation.
There will be a continuation. ठीक है डाकिलो ये गोटे मिनट के लास्ट
Only 3 copies of this.
3 copies of this order be handed over to Sri Patnaik for compliance. It is item 12, I think.
Item 12.
We have on the basis of notice, I am opposite number 3, principal of the college.
One minute.
No, state has not.
In this case, your lordship directed to place all the cases before the division bench, previously directed. Because here the prayer is to extend the financial benefit from the date of applicability of the pay revision rules, 1/1/2006. Thank you. No, so many cases your lordship has directed to place before the division bench.
Notice counter
No, I have not, there is a direction, but your lordship has, before vacation, summer lordship directed in the. No, has to, they are in the.
We carry cross there the government resolution as well.
Division.
Anyway, I just recording the appearance and then. Since this case involves damage to the government resolution dated 2020. It is not to examine if this is to be placed before the division bench or disposal. Item 19.
Well, in fact, no, submit this, yes. Yes.
Item 20.
Actually, Mr. Subhidar told me.
Item 20.
There is a direction of appearance
Yes,
of the
not the
Director Secretary
director
Education
is
of
present.
SAP.
And he is filing an affidavit.
Sir, appearance must be there.
Yes, yes.
That the direction
he is there.
must appear. He has not appeared.
No, no,
today.
he has not.
Appeared.
What was the director?
To produce the record, the hard copy of the affidavit, I am serving a copy.
What is the affidavit?
No, records are not traceable. In fact, it was before the regional director. And during Hon'Ble, it has been destroyed.
Quebec?
Hon'Ble.
Hon'Ble.
Yes.
Sir, Bhubaneswar Hon'Ble restore hota pratham thar shunchi.
Anyway, let us see the update on record.
Yes.
The Mohammedan Bari. The director of such a verification of the application of the legal person finds an affidavit inter alia. Getting that the record in question
Paragraph 5.
was being dealt with was available and was kept in the office of the regional director. Was destroyed in Tommy cycle.
There was a report prepared. And that.
Sir, not a reply, Devi. There's some, yeah, there's some my copy. I will give a reply.
That I have annexed as annexer D by. Yes, in this affidavit. Whatever, yes. Whatever was placed has been submitted. D by 2.
The available documents have been included. Further,
Yes.
Yes, to look in it. Sir, I will give a reply.
He has assumed office that he has stated
Yes, that I will
on
give the reply.
2/4/2024. Assumed the charge.
What is this matter about?
Sir, taku direction diaitala. Je that the whether as to the petitioner or opposite partner of both that to continue as the clerk of the institutions. They have, that is why this honorable director, you will cause an inquiry and come to a conclusion who is the person to be approved as the clerk.
But why did we call for the original record? What was the dispute that we called?
Because we said that at the time of hearing, we were not heard and we are not given any benefit. That is the reason why your lordships are pleased to ask for the documents.
Oh, so we had submitted an application for intervention.
Yes,
that was never considered.
I was not considered.
So I wanted to know whether that application for intervention was available in the record or not. Mr. Ras,
pardon.
That is what I wanted to know, whether the application for intervention, as he suggests, that he had filed, but it was never taken into consideration. Whether that application, such an application is pending or not.
Under the helpless situation now, it
So
can
we'll have
be
to,
certain.
we'll have to accept his version.
And my,
What is the view of the director? Yes, Mr. Malik. Yes, obviously you have joined very recently, you cannot say, but so has any serious effort been made to trace out the file?
that has been analyzed in the.
No, I've seen. We can only.
That office has taken all the steps to trace out the file. Even my two of my staffs, I have deputed them to trace out the file, but no result.
Then we will take it as if whatever he says is correct. So far as the merit of the case, if you have not heard.
Accepting that if your lordship considers the prayer is, and this honorable court to direct the appointment part number 3 to conduct the inquiry afresh.
Yes.
For giving, if that is.
Yes, my lord.
Who is to hear the matter? Mr. Malik, you are to hear the matter. Mr. Malik is to hear the matter.
Director is to hear the.
Let him hear the matter again.
Yes.
What do you say, Mr. Shekhar?
Your lordship, from the inquiry report also, it is assumed that the present petitioner were represented by one Shri D.N. Rath.
D.N. Ratha, one D.N. Ratha. D.N. Ratha advocate, they don't write D.N. Ratha advocate. One D.N. Ratha, as if he's an outsider.
On production of Vakalatnama. It has been, it is quite apparent from the finding of the inquiry report, your lordship.
Thank you.
Which is available at the affidavit filed by the government, your lordship, at page 4.
Aji?
No, on earlier it was filed.
Earlier the additional affidavit?
Yes, my lord.
Additional affidavit
filed by the government, your lordship.
Government level key, district education also na key.
This has been by the DO, your lordship, DO Moirpant.
At paragraph?
The inspector, not the government, sir. The DEO is the inspector of schools. He cannot give an affidavit on behalf of the state government.
But there is the inquiry report has been produced.
No, my lord, I will give a reply.
Already let him give a reply.
Yes, I will give a reply.
The files and affidavits, so. Sri J.K. Rathal and senior counsel for the petitioner upon whom a copy of this affidavit has been served wants to file a reply. List this matter
19th July.
on 19 July.
Yes, sir.
The personal attendance of Sri Malik is dispensed with.
Probably.
Yes.
I may also be served with a copy of that affidavit which was filed.
Yes, let the copy of the affidavit be served upon
Yes.
level counsel for opposite party number
7, your lordship.
private opposite party. On the private opposite.
Great for me.
You are calling it off?
19th July.
19 July.
Obliged.
Item 21.
19.
Yes, 19 July. Item 21.
My lord, on the Mr. Sanjeev Bhai.
How Aji pass over nahi.
I took time.
No, after 2 p.m. other matters are there, so Aji hoga nahi.
Mr. Swines and from Slowness. Urgent matter.
Mr. Lenka, take it up next week then. As requested on behalf of Sri Sanjeev Swine, is this matter next week? The total he kori ki labo kahan ho? We'll take it up next week.
Last time,
Item 22.
22. Anybody appearing? 22? Yes.
I am for the petition.
You are for the petitioner?
Man,
Yes, please.
last petition, lordship directed the.
Because of
The affidavit was to be filed, but again a failure.
Well, in election duty.
No.
What, Mr. Das?
No. Last month it was so. Now they cannot take that plea. Immediately I had informed them and telephoned them. The last chance to go.
Last chance is granted to the state to file counter affidavit. Telling which the matter shall be disposed of on available pleadings. List this matter on
12 July.
12 July.
Item 23.
Petrachi.
Item 23. Today I am filing the counter, my lord. Serving the copy to the petitioner as well as my learned senior appearing for state.
ये matter ये तो कितना Approve it. Serving the special notice नहीं की तब जीवा आसी नहीं फिर से सकाल में संकलम कोई यहाँ बोले ये मौसम कुछ हैं? पता ही I respect. Yes, Mr. Das.
Counter, my lord, I am filing the counter or serving the copy to
All right, Sri S.K. Das, Learned Counsel appearing for of the opposite party number?
opposite party number 5, man.
Opposite party number 5 files counter, copy of which is served on the other side in course of the day, in court. Let's matter. Good number, okay.
26 July.
26 July.
Okay. The
You know, we probably file in the meantime. Counter दे दियो. Yes, sir. Counter be kept on record.
24, my lord, the opposite party number 4 have filed the counter. Will file a reply to this.
When did you file counter?
We are received on 18/4, my lord. 18/4, we have received on 18/4.
When counsel the petitioner wants to file rejoinder to the counter filed by the opposite party number 4, list this matter on 26 July.
Yeah, I'm for the opposite party number 5. I will file counter.
Entry model.
Counter affidavit by other opposite parties, if any, be filed in the meantime.
Entry model.
Entry model to court.
Hard copy of the counter from the kind of from
The state council files physical hard copy of the counter in court. Stop, send be kept on record.
26
July.
Item 25, if I my lord, I pray next week because मैंने से फाइल टा भूले नहीं गला से गला शॉर्ट से भूले आधा फाइल नहीं गला से हम तुम पासवर्ड पे अपन
कौन आप ओकिल की दिन अपना फाइल के लिए होची नहीं आ फाइल टा तो मेन ओकिल फाइल चली गला और रहला कौन सा पकड़ who has taken away your brief
जैसे मिस्टर शाह नहीं गला भूले हम एसोसिएट
बोला एसोसिएट যদি ব্রিফ নেই যাଉଛନ୍ତି মানে গলা
ब्रीफ नो
ସେଇଟା ଆପଣ ତ ସେୟା କହିଲେ ଆମେ ଯା ବୁଝିଲୁ as requested by Sri Ratha, Learned Counsel for the petitioner, list this matter
नेक्स्ट वीक
next week হবো কি দেখলো next week
हेलो नेक्स्ट वीक
next Friday
Item number 26.
consider extension by SC 3 months time is allowed to the court below for disposal of the case.
Item number 27.
Well, please, Your Lordship. Lordship, I'm seeking one modification of the order dated wherein this honorable court has pleased to allow the bail application with the condition at paragraph 9 that the petitioner shall personally appear on each and every date of posting of the things at the trial. But Lordship, petitioner being a doctor is unable to present at each and every date of posting.
He's a doctor?
Yes, doctor.
Wherever you said that he is a doctor, जो कोर्ट में लिखा है नहीं हाँ लिखा है डॉक्टर स्पेशलिस्ट इन गायनेकोलॉजी इन CHSC Charichopa.
Yes, Lord.
Yes, we'll modify it. Prayer for modification, considering the submissions, the prayer for modification of order dated 9/3/2022 is allowed only to the extent of exempting, only to the extent of waiving the condition of the petitioner personally appearing before the trial court on each date of posting of the case. Stop. He shall, however, appear
as and when required.
As and when required by the court.
My presence were kindly noted.
Called Sri Das vehemently objects to the prayer for objection.
No objects. Only presence.
ରହିବ ସେ କନଷ୍ଟାଟିଲ ରହିବ
ହଁ ସେଇଥିରେ ସେ ଜାଣିଛନ୍ତି ନା ନାଁଟା Sanjay Kumar standing counsel.
If the petitioner could not present on that date, can he be filed on 317 application for the date?
That is there. That is there.
ହେଲାଣି ୱେଭ୍ ହେଇଗଲା ମାନେ କଣ୍ଡିସନ ମାନେ 317 will be allowed.
317 is applicable. Okay. Item 28.
Alright, I mentioned here on behalf of Mr. Pandit. We are filing a high case and in this case we have to refer
Belgium matter.
Time.
Belgium. Yes. Yes. 2 weeks further time is allowed to the petitioner to 2 weeks further time is allowed to the petitioner to appear pursuant to order dated such and such.
Item 29.
May I please, let's see. An allegation under section 302, 34 of the Indian Penal Code, my lord.
Case diary ଅଛି?
My lord.
Case diary?
Case diary is not available, my lord. It has not been called for. I think so.
The first time.
Deposition copy they have supplied. I have supplied the all deposition copy.
Yes, what do you see?
Not all. PW 10 is the informant and PW 8 is the brother-in-law of the deceased.
Now, we would like to know who are the eyewitnesses?
Eyewitness is the brother-in-law, my lord. PW 8. Only eyewitness.
Your name is Jitendra Sahu?
My lord. Montu. My name Sangram Sahu Montu. My name is Montu and Chubby alias against Chubby, my lord. There was allegations.
No, there was a direction to remove there after examination of Vijay Kumar Sahu. Has he been examined?
Yes, my lord. I have supplied the Vijay Kumar Sahu is PW. My lord, he is the eyewitness.
He has turned hostile.
Not hostile.
Yes, ଆପଣଙ୍କ ନାଁରେ କହିଛନ୍ତି?
ଫାର୍ଷ୍ଟ ପିଟିସନ ନମ୍ବର 1 ନାଁରେ କହିଛନ୍ତି ଡାଇରେକ୍ଟ ଆଲିଗେସନ ସେ ତାକୁ ଆଟାକ୍ କରିଛି ଆଉ ସେକେଣ୍ଡ ନାଁରେ ଓବ୍ଲିମସ୍ ଆଲିଗେସନ ତା ସହିତ ଅନ୍ୟ ମାନେ ପ୍ରାୟ ପାଖାପାଖି 70-60
named including the petitioners.
yes but 26 against assault direct allegation I against ଇଏ ଅଛି ଓବ୍ଲିମସ୍ ତା କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ my lords
So that Hon'Ble case.
My lords.
Boji kariya ପାଇଁ se
Accused person Torani Sahu and Chhabi Sahu came to my in-laws house and called my brother-in-law. You are not either Torani Sahu or
I am Chubby. Petition number 1 is the Chubby.
Chhabi Sahu?
Chubby and
two which Montu, Sangram Sahu.
two petitioners.
Chubby I am not pressing man.
Not name is also there. He has called and
Oh, not करथिले मुझे प्रेफरेंस सीट में not press करथिले Mr. Pandey. He could sense that the court is going to reject it.
No, my lord. From the beginning, I could have submitted that. A Montu tare 25 pre kahila.
From the beginning, you could sense that the court is going to reject. That is why you not pressed.
No, my lord's predicament, my lord. 25 pre tar.
I went towards Derjang Dam and found the accused persons Torani Sahu, Chhabi Sahu, Binoy Das, Jittu Biswal, Jittu Sahu, Govinda Sahu, Montu Sahu.
Yes.
You are Montu Sahu.
Montu Sahu.
Koibel Sahu, Montu Behera, Silu Sahu, Vibhuti Sahu and Hari Sahu and 2 other ladies were assaulting my brother-in-law, namely Jagan Senapati by means of Thenga, Badi, Bhujali, Khonda. I noticed the said incident through my motorcycle light. I shouted loudly by saying Jagan and the accused persons after hearing my
Clause number 25 of the cross-examination lordship may see.
Yes.
My lord, on the alleged date, accused Chhabi Sahu by holding the sword was assaulting my brother-in-law. One Binay Das by holding the sword was assaulting my brother-in-law. Govinda Sahu and Hari Sahu were assaulting my brother-in-law by means of Bhujali. Other accused persons by holding Thenga, wooden plank and bamboo stick were assaulting my brother-in-law.
I'd like to know whether he is the only eyewitness or there are other eyewitnesses.
Only eyewitness.
no, only.
Only eyewitness.
All right. No specific overtake. No specific overtake. The petitioner is in custody since?
My lord,
That should specify the petition number 2. Not present.
Yes, petitioner number
19/9/2021.
Petitioner, the counsel for the petitioners submits that the bail application in respect of petitioner number 1 not लिख देबो be dismissed as not pressed. Bail application in respect of petitioner number 2 not is taken up for hearing. The petitioner number 2 is in custody since
19/9/2021.
19/9/2021 in connection with such and such case. The prosecution case is that one Torani Sahu and the petitioner number 2 came to the house of the deceased, Jagannath Senapati, and called him to participate in a feast. They took him on a bike, followed by one Binoy Das. When he did not return, his family members and relations went to search him and found that he was being severely assaulted by all the accused persons near Derjang Dam. Because of such assault, the deceased sustained grievous injuries to which he ultimately succumbed. Sri A.K. Pandey, learned counsel for the petitioner, produces copies of the depositions of the witnesses, of whom P.W. Vijay Kumar Sahu is the eyewitness. Perusal of the deposition of Vijay Kumar Sahu, Secretary P.W. reveals that he has generally deposed about all the accused persons assaulting the deceased. However, in cross-examination, he has Chhabi Sahu achi.
Chhabi हम practice करेंगे. It's number 1.
Oh, you are Montu.
Montu भी अच्छी, but general is Montu is tonight. Chhabi is specific.
However, in cross-examination, said witness has specified as to which accused was assaulting, which accused had assaulted the deceased by using which weapon. Significantly, the name of the petitioner number 2, Montu Sahu, does not find place in such cross-examination. As such, there is a reasonable doubt with regard to the presence of the with regard to as such, no specific overt act has been attributed to petitioner number 2. In such view of the matter, I am inclined to take a lenient view, particularly considering the period of detention in custody. Let the petitioner be released, each to appearance.
Depluralized.
Item 30.
Also, interim bail regards to marriage of the daughter, madam.
Interim bail?
For the marriage of his daughter, madam, which is going to be performed on 12/7/2024. Eldest daughter.
12/7. We'll pass the order next week.
I will take instruction to that effect. 12 तारीख अच्छी तो so
I play one Mangala, Patak Sadar.
All right.
Second.
This matter on 2nd July. Learned State Council shall take instructions with regard to the amendments made in the IO.
Yes.
Item 31.
My pleasure. Let's say para 6 column 1. Let's say pray for mention as a every Sunday appear before this Kujanga police lordship pray last Sunday every month last Sunday appear this daily just labor काम କରିବାକୁ ଯାଇପାରୁନାହାନ୍ତି.
Prayer for modification is allowed. Instead of every Sunday, the petitioner shall appear on every alternate Sunday. Before the IAC, yes.
Item 32.
May I please, Your Lordship. 20B2C, petitioner before your Lordship is a young boy, aged about 22 years, and he is in custody since my Lord 24/2/2022. Since my Lord he is in custody, and in the meantime, my Lord, that out of 3 charge sheet witnesses, I have annexed that annexer, my Lord, 2 series. That out of 3 charge sheet witnesses, 2 witnesses has already been examined since long, since 25/1/2023. Last witnesses, my Lord, that page 2021. That last 9/2/2023, last witnesses was examined. And I have no criminal antecedent, nothing. And your lordship was pleased
Supported
to,
the prosecution. They have examined and supported the.
they have two out of three charge sheet witnesses, two were examined and they are the official witnesses. And since my lord 9/2/2023 till date, no one another witnesses, remaining witnesses my lord, is not coming. And I have no criminal antecedent, nothing. Aged about 22 years, young boy, my lord. I pray before your lordship, he is not an outsider. And my lord, that two of the witnesses has already been examined. And I am in custody since 24/2/2022. So any strengthened condition, my lord? Being a young boy, my lord.
The petitioner is in custody since
24/2/2022.
24/3/2022.
24/2 February.
24/2/2022. In connection with such and such case, it is alleged that the petitioner was in possession of 102.5 kgs of contraband ganja when he was apprehended by the excise officials. Sri Sahul and counsel for the petitioner submits that out of three charge sheet witnesses, the peer witnesses, only two have been examined. Only two have been examined, with the last witness being examined on
my lord 25/2/2023.
25/2/2023. That is more than 1.5 years ago.
9/2/2023. 9/2/2023.
He therefore submits that the remaining witness is not turning up despite repeated summons issued by the court. He therefore submits that taking into consideration the delay in conclusion of trial, the petitioner may at least be released on interim bail. Having regard to the submissions as above and the delay in conclusion of trial, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 3 months.
Earlier occasion, your lordship was pleased to allow 3 months, and in the right time he surrendered.
ଗୋଟେ witness ଅଛି ହେଇଯିବ ସରିଯିବ
3 months. Yes.
Item 33.
May I please? The present petitioner is inside. He has been apprehended on 8/8/2021. And my instruction, my lord.
No instruction.
To my instruction, not a single witness has been turned up. Out of my lord, 24.
You were granted interim bail for 4 months.
And right time he has been surrendered. Each and every time he has surrendered in right time. He has never violated any terms.
Extension भी
That is it. Due to illness and actually he was suffering.
When did he last surrender?
My lord?
When did he last surrender?
On last surrender, my lord. That is 29/4/2024.
How the mass?
पूर्व surrender करछि सेदिन bail book 29/4/2024.
The petitioner is in custody since
8/8/2021.
8/8/2021 in connection with such and such case. It is alleged that the petitioner, and
another
petitioner and another person were in possession of contraband ganja weighing 693 kgs, 450 grams, and were transporting the same in a car. Maruti Swift
Maruti Swift Desire
in a car when they were apprehended by police. It is submitted that trial has not commenced. Trial has not commenced even till date. Taking note of which, this court had earlier directed the petitioner to be released on interim bail for a period of 4 months, as per order passed in BLAPL number 7657 of 2023. It is submitted that the petitioner surrendered to custody in time without misusing his liberty. It is further submitted that since trial has not commenced as yet and the petitioner has been in custody for kete, for nearly 3 years, for nearly 3 years, he may be again released on interim bail. Considering the submissions as above and taking note of the delay in commencement of trial, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 3 months.
Black.
Item 34. Public. Item 34 may have legal lodging. Item 307, 354, 452, 294, 323 IPC my lord. My lord granted co-accused on bail subject to verification of this injury. My lord.
Yes,
Injuries are simple.
but specific allegation against him. Mundu ko badela cut.
Same order.
Yes, ma'am.
Same order.
Subject to verification.
Simple injury. Obliged. Yes. Item 35.
31, 341, 294, 323, 353, 506. Allegation of Vidyut bill, collection of electricity bill. There was a verbal altercation between the petitioner that why the power cut is in the last night.
Manoj, সরকারি লোকଙ୍କୁ ବାଡେଇଲେ କି ବେଲ ଫେଲ ନାହିଁ
First or second.
ସରକାରୀ ଲୋକଙ୍କୁ ବାଡେଇଲେ ମୁଁ ସେଇଥିପାଇଁ ଲାଷ୍ଟ ଟାଇମ ଆଇ ରିମେମ୍ବର
Withdraw. Yes.
ୱିଡ୍ର କରିଥିଲେ ଆପଣ ହି ରିମେମ୍ବର୍ସ
Yes. First or second or.
ଇଲେକ୍ଟ୍ରିକ କଲେକ୍ସନ ଯେ କରିବାକୁ ଆସିଥିଲେ ଇଲେକ୍ଟ୍ରିକ ବିଲ୍ ତାଙ୍କୁ ବାଡେଇଲେ
Case counter case କରି କରିଛି.
ସେ ହବ ବାଡେଇଲେ The petitioner is apprehending arrest in connection with such and such case. It is alleged that when the informant, being an employee of the electricity company, had was collecting electricity dues in the village, the petitioner restrained him, abused him in obscene language, and threatened to kill him. Stop. It is submitted that the allegations are false and have been foisted as a counterblast to a case registered at the instance of the petitioner. Considering the nature of accusations and the materials on record, first or second.
Obliged.
Weekly list ଖାଲି ରଖିଦେବା ନାଇଁ ଟ୍ରାନ୍ସଫର ରଖିବା ସ୍ପେଶାଲ ନୋଟିସ୍ ଆସିଯାଇଛି ଆସିନି ମଗେଇ ଦିଅ ସ୍ପେଶାଲ ନୋଟିସ୍ will be taken up immediately after matter. Yes, Mr. Mishra.
Second appeal which was passed over the whole week because I couldn't come. So, matter has been dismissed on the ground of delay. That matter, my associate was moving. Now it was passed over yesterday and day before also.
Dismissed or
no? It was second. The first appeal has been dismissed on the ground of limitation.
I'll consider it after recess. Kete item kete?
75.
Yes, I'll call out the entire list. Whoever doesn't appear will meet the same fate.
No, I'll be there today.
No, yesterday I made it very clear that all matters beyond 5 years, I've called out for 5 days now. I will not wait. 5 ବର୍ଷ ଭିତରେ ଯାହା matter ଅଛି ତାକୁ I will grant another opportunity. But even if it is a second appeal.
No, today I'll be there.
Yes. ଅଳ୍ପ ସମୟ ତ କୋର୍ଟ ହବ ତେଣୁ that is only on the ground of limitation your first appeal was
Yes.
Okay.
my lord, this administrative ground, there is a decision of this honorable court, that is annexure 4. I have quoted in my. This is the judgment of the Honorable Justice Mahapatra, sir. Where it is clearly mentioned, my lord, that they are taking a plea as administrative ground and basing on that they are transferring.
Who's the Railway Council?
Union of India.
You should have served a copy, Mr. Mishra.
Yes, I have served, man. I have served a copy.
You have served?
Yes, man, I have served.
But there is nobody. କହିବେନି ଆପଣ ଗୋଟେ ସ୍ପେଶାଲି ନୋଟିସ୍ ଟା ନିଆଯାଉଛି ବୋଲି ତାଙ୍କୁ କହିଥାନ୍ତେ ନା କେମିତି how I am going to pass an interim order then how interim order ତ ଆପଣ ଫାଇଲ କରିନାହାନ୍ତି ଆଇଏ?
No, my lord. But I have no, I is there.
So why is the urgency? What is the urgency then?
I is not.
ଆଇଏ ତ ଫାଇଲ କରିନାହାନ୍ତି ଆଉ ଟ୍ରାନ୍ସଫର ଆପ୍ଲିକେସନ ଚାଲିଛି କଣ ହବ ତାହେଲେ?
For the timing, my lord, stay may be granted. I'll intimate the Union of India, Council of the Union of India.
No, what is your interim prayer here? Nothing.
Well, there in the main prayer I have mentioned.
Main prayer कौन अपन? Quashing
to allow him at present to continue in the present place.
So where is in the absence of an IE, how can he pass the order?
I'm sorry, my lord, for the timing it may be.
किमिति आगे हबो
That is prayer number 2, my lord.
ଆପଣ ଗୋଟେ ଆଇଏଟେ ଫାଇଲ କରିବେନି ଆପଣ ଟ୍ରାନ୍ସଫର ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିବେ ଫର କ୍ୱାସମେଣ୍ଟ ଆଣ୍ଡ ହାଉ ସେଇଟାକୁ କରିକି ମୁଁ ଆଜ୍ଞା ଗୋଟେ ଅର୍ଡର ଦେଇଦେବି
I'm sorry, my lord. I'm sorry, but for the timing,
ହାଉ କ୍ୟାନ୍ ଆଇ ପାସ୍ ଦ୍ୟାଟ୍ ଅର୍ଡର ଟେଲ୍ ମି ଆଇଏଟେ ଫାଇଲ କରିଥାନ୍ତେ କେତେବେଳେ ଫାଇଲ କରିବେ ଆଜ୍ଞା ମୁଁ ଆପଣଙ୍କୁ ସକାଳୁ ଆପଣଙ୍କୁ ମେନସନ କରିନି ଆଇ ଆଲାଉ
sorry,
if you don't want to take relief I can order relief.
Extremely sorry.
When is he going to be relieved?
My lord, today itself, that's why.
देखो अपन ये तो केमिति how are you are not helping your client Mr. Mishra.
I'm sorry, extremely sorry.
You have not applied your mind, you are not ये decision टाକୁ ଦେଇଛନ୍ତି how can he pass the interim order now I wonder. Yes, Mr. Das, help me.
If my lord friend files an application before your lordship rises, then only something can be done.
No, he cannot file. ଆଉ ଦିଟା 20 ମାନେ ଫୁଲ ଡେ କୋର୍ଟ ହେଇଥିଲେ ହେଇଥାନ୍ତା we are rising at 255
reference there.
ଆପଣ ଏତେ ସମୟ ବସିଲେ ଯଦି ସେତିକି ଖାଲି କରିଥାନ୍ତେ.
I'm sorry.
ये हमारा इनिशियल पार्ट लिखिया କଥା लिखिदेବେ ଯେ this matter not in our list so special notice released ହେଲା. Learned Sri A.K. Mishra, Learned Counsel for the petitioner submits that copy of the writ application has been served upon कहाँ ऊपर है?
Union of India.
नहीं रेलवे से अलगा ना?
नहीं
रेलवे वाला यूनियन
has been served upon the panel advocate of the Union of India. Had you informed him that the matter will be taken up today?
No, I have not.
Since the matter is taken up on special notice, obviously the Council for Union of India being unable to, being not aware of it, could not appear. Place this matter on Monday, indicating the name of the Central Government Union, Central Government Council will go to Central Government Council. Yeah. Till such time, the petitioner shall not be relieved from his present post, if not already relieved. Yes. Also file an IA to regularize this order. तापर कहिए जो कोर्ट इलीगल ऑर्डर पास कर ले
list item number 10.
Item number 10. None appears on repeated calls. The matter being in the weekly list has been called out every day since Monday. Since there is no appearance, it is presumed that the appellant is no longer interested to pursue the IA will go IA to reject kar orders are seen no longer interested to pursue the IA, which is therefore dismissed for non-prosecution. List the appeal for has it been admitted?
Yes, admitted.
Then we'll take it up for hearing. List this matter for hearing in the week commencing
8th July.
8th July. Yes.
Item number 25.
25 is order 41. Nepal. PRPC. Lokondu CI Lokondu, none appears. On repeated calls. The matter being in the weekly list was called out every day since Monday. Monday through Friday, bracketed today. It is therefore presumed that the petitioner is no longer interested to pursue the application, which is dismissed for non-prosecution. A similar order, जो से dismissal होगा इधर पास करिए. Yes.
Item 26.
Item 26, same order.
Item 31.
31.
And for the respondent.
Respondent dismissed for non-prosecution.
Item number 36.
Yes.
Also on behalf of Mr. A.K. Pandey, your lordship. The transfer of the petition, CP number 94 by 2016, from the learned civil judge, senior division cum family judge Kujang to the court of learned judge, family court Kendrapada.
Wait, what go? What is this case about? DD case. Sir, this is a DD case. पढ़ना थी फाइल पढ़ना चाहिए. I am dismissing it. Release this matter.
The case
Release this matter next week.
filing under section.
All it. Release this matter next week. पढ़ी जासन.
Item 39.
कोर्ट को न पढ़ेगी मोटा आशीर्वाद. Item 39 dismissed.
Item number 40.
40.
Thus, you on behalf of Mr. A.K. Pandey, your lordship.
पढ़ी जल्दी. Next week.
Item 41.
Dismissed.
Item number 42.
Dismiss.
Item number 43.
Same.
Item number 44.
Same.
Item number 45.
Same.
Item number 49.
Dismissed.
Item number 50.
Dismissed. No, this is 50 though. Permitted to withdraw. See, what I file question permitted to withdraw, or connected matter to be permitted to withdraw. Yes.
Item number 53.
Dismissed.
For the opposite.
Dismissed.
Item 54.
Yes, Mr. Das.
Your lordship, for not approving when the matter was called out.
No, today you are here. No,
That is the matter related.
in case 2019 matter को dismiss करिबनी. 5 वर्ष बोली कहिछि. 5 वर्ष पूर्व जोड़ा है
My duty to when the matter was.
Yes. Yeah.
That the matter relating to transfer of the 125 proceeding from Bhubaneswar to the only petitioner is husband.
Bhubaneswar to?
Bhubaneswar to Parampur.
Bhubaneswar to Parampur.
Yes. Only JMFC Khalikot, Parampur, Khalikot. Khalikot.
What is the status of the case? Present status? There was a stay. That, has he applied the Asian resurfacing?
No, there is only stay of that.
No.
There, I do not. Can't say the stay got you loves.
2019 रो stay तो और नथिबो नथाई पारे.
I'll take instruction.
Take instruction.
Next week.
Sri B.S. Das, Learning Counsel for the petitioner, requests for an adjournment in order to take instructions with regard to the present status of the case.
Status.
Present status of the case पर कौन जल्दी stay का बहुत vacant निकला.
किंतु जल्दी
It is pending before खोला. This is बरमपुर.
हाँ नहीं pending before Bhubaneswar.
Bhubaneswar. कोई वो नहीं. May have been
for your lordships. I must.
Let's this matter next week.
Yes. Okay.
Item 55.
55 none appears next week.
Item number 58.
None appears next week.
Item number 60,
None appears next week.
item 61.
Same.
May I please?
Sir, 61 వచ్చింది కదా.
My lord, seeking for transfer of a proceeding under section 9 of Hindu Marriage Act from the learned judge of the Tamil court, Baleswar to Baripada. My lord, here, my lord, annex of 1 is the medical document.
Okay, appear করনা will transfer it upon. On the ground of medical illness. On the ground of illness.
Illness, no, my lord, that is life risk because twice, thrice she was subjected to lethal attack. And another proceeding is also pending there at
Baleswar.
Ethnoti.
মানে Mayurganj.
Yes, that is annex of 2 is pending.
All right. The petitioner, who is the wife of the opposite party, seeks transfer of CP number 40 of 470 of 2021, pending the Court of Languages Family Court Baleswar to the Court of Languages Family Court Baripada. Said case has been filed by the opposite party under section 9 of the Hindu Marriage Act. Therefore, transfer has been made on the ground that the petitioner is presently residing with her parents in her village under Boisinga police station in the district of Mayurganj. Actually, Boisinga is closer to Baleswar than Baripada. It was submitted that another proceeding between the parties is presently pending in the court at Bethnoti. Under such circumstances, it would be inconvenient on her part to travel to Baleswar to attend to attend the court on the date fixed. Para. Considering the grounds on which the prayer for transfer has been made, and looking at the relative inconvenience likely to be caused to the parties if the proceeding continues at Baleswar, this court is of the view that it would be convenient if the proceeding is transferred to Baripada. Hence, order koi kar dega. Yes.
Item number 62.
Who's for the petitioner? Yes, anybody? None appears for the petitioner. None counsel for the opposite party is present. Let's this matter next week.
Item 63.
See you next week. None appears next week.
Item 65.
65 is yours.
That's 65, my lord, next week.
Next week as paid for.
Item 66.
Interim also.
In order to continue.
Lordship, in item 66, I am for the petitioner
Yes, please.
wife. Lordship, I am prayer for the transfer of a civil suit of a matrimonial dispute from the family court Jharsuguda to civil judge senior division.
On what ground?
Your Lordship, petitioner is a unemployed woman and she living with his old parent with her minor child.
All right.
And 3 other case pending in the Rajgangpur JMFC court.
All right. Prayer for transfer has been made on the ground that the petitioner is residing with her old parents
And mine.
and a minor's child. So further, Ketara proceeding?
3%.
3 other proceedings are pending in the courts at
JMFC first class Rajgangpur.
Rajgangpur. It is submitted that it would therefore be convenient for her if the proceeding is transferred to Rajgangpur.
Oh, bless.
Item 68. It will be withdrawn individually.
Permitted to withdraw 68, sir. All right.
Item number 71.
None appears dismissed. Say करो ना जैसे लिखी पूरा करिए. You has been called out every day since Monday. No, none appears dismissed. Yes.
Item 75.
The first appeal has been dismissed on the ground of limitation. There was a delay of about 3.5 years. Now that order, my lord, begins from page number 20.
Somebody was arguing this matter.
My lord, my associate, my lord expressed an opinion that he was actually.
Oh, that section 14 thing.
No, 14 will not apply. We are not taking the plea of 14. Suit was dismissed. My lord knows the ground realities. The lawyer filed a review. Review was ultimately dismissed on the ground of limitation as well as on merits. Now we have preferred the first appeal. First appeal, there was a delay of 3.5 years. So the question is whether pursuing that review can be a ground for condonation of delay and whether pursuing of a review would fall within that expression of sufficient cause under section 5. There, my lord, we have got a judgment which says.
But the only thing, Mr. Mishra, what I found yesterday, the review itself was delayed.
There was a minuscule delay in filing the review.
No, not minuscule delay. There must be. The suit was dismissed on 17/1/2018.
My lord.
Declared on 18/1/2018.
Dismissed.
Review was filed on 19/6/2019. So after 5 months.
My lord. 5 months. The period is.
So say period that is standing in the way.
So obviously, my lord, 14 will not apply because review was never a wrong forum. Here, 14 will never apply. Had we prayed for 14, then of course what falls from your lordship is correct.
Why will it be not treated as a why will it be treated as a wrong forum? Even it has to be treated as a wrong forum because review is not maintainable, isn't it?
Review was maintainable.
Review was maintainable.
Yes. Review been dismissed on the ground of territorial jurisdiction or wrong forum, then 14 could have come. But there is a judgment which says that pursuing of a I'll try to persuade your lordship. Para 25.3 of it's a Supreme Court judgment. Yes, paragraph 25.3. The third situation with which we are concerned in the instant case is where the revision petition is filed before the tribunal, but the tribunal refuses to interfere with the decree or order earlier made. It simply dismisses the review petition. The decree in such a case suffers neither from any reversal nor any alteration or modification. It is an order by which the review petition is dismissed, thereby affirming the decree or order. In such a contingency, there is no question of any merger or anyone aggrieved by the decree or order of the tribunal or court shall have to challenge within the time stipulated by law the original decree and not the order dismissing the review petition. Time, this line is important. Time taken by a party in diligently pursuing the remedy by way of a review may in appropriate cases be excluded from consideration while condoning the delay in filing of the appeal, but such exclusion or condonation would not imply that there is a merger of the original decree or the order dismissing the review petition. So all that, my lords, we are saying is this 3.5 years. Review was filed after, no doubt after 5-6 months, but there was a pendency. The court took its time to dispose of that review. And after that, my lords, of course, I can't, in absolute mathematical terms, we have not been able to explain. But my lords, there was a COVID pandemic in between. This comes within the COVID pandemic.
No, your cause of action arose.
No, that
prior to that COVID pandemic.
But so the extension, the Supreme Court orders will not apply. But the fact that there was a COVID pandemic and during that period, there was such a huge, the entire world suffered it. So isn't that a factor for condoning? Now, 3 years is what we are looking at. Supreme Court excludes COVID from 15/3/20 to 28/2/22. Isn't that a factor for condoning delay matters? Or that's the question which you are raising here.
All right. Let's see. Gautam Mishra, Learned Senior Counsel with
It is with A. Maharana. Anubhav Maharana. Anubhav Maharana.
A. Maharana. Then counsel for the appellant. Appellants.
Appellants.
Appellants. Producing impugn judgment. Considering the submissions and the grounds raised, the appeal is admitted on the following substantial question of law: whether the first appellate court was correct in dismissing the appeal on the ground of delay, ignoring the fact that the appellants were diligently pursuing the remedy of pursuing the review application, as also the situation arising out of COVID-19 pandemic. Issue notice to the respondents by registered post with it, by speed post नहीं होता, by speed post. वैसे ये भी दरकार होने, LCR भी दरकार होने,
नहीं,
by speed post, fixing a short returnable date. Requisites be filed by Monday peremptorily. Lest this matter, August over date करो.
Do we commencing 12th August?
Commencing 12th August for hearing.
We are all grateful to you, Lord.
Item number 79.
You are ready to see us?
Yeah, of course.
No, but what I am saying is that there will be no time, so I will record your appearance and post it to next week.
As your lordship, please just.
That will be better. Sri S.K. Das, learned counsel for the appellant, is present. None appears for the respondents. Let's this matter next week.
Item 80.
Item 80.
For the appellant, your lordship.
Who's for the other side?
No one has appeared, your lordship.
No one has appeared.
Earlier they used to appear, but
आज तो time होगा नहीं कौन करे?
your lordship.
पूरा दिन कोर्ट से I would have taken up one or two matters, but for hearing. So I'll simply adjourn it. Next week.
Oblige. Item 83.
Both sides are there. Both sides are there. You are the appellant.
Yeah, I'm for the appellant. Let's Mr. SP, Mr. Senior Advocate is to.
Next week. As paid for.
Oblige. Item number 92.
Sir.
I am not ready.
Both sides.
Both sides.
I am not ready.
Sri S.K. Das is present. Sri R. Das, learned counsel appearing for the respondent's request for an adjournment. Let's this matter next week.
Hello.
Item 93.
93. I think 93, Mr.
I'm there.
Samudra.
For the appellate.
We'll say we'll make it part third. Third and part. Let's this matter next week.
Item 94.
2016 matter. Next week. चलेगा चलेगा पहले should we begin? You are the other matter.
79.
I mean, you are ready. At least 10-15 minutes.
Yes, sir.
10 minutes we can. Pathar karo.
Hello.
10 minutes. Let us say up to 3:50.
So much time is will not be required for your loss. In the present case, my lord, it's a cell deed which was in challenge, the subject matter, on the ground that a fragment has been created. And again, claim for repurchase was also made. That has been refused.
Fragment created without taking permission of the consolidated.
Without taking permission.
Section 34. Right.
Then repurchase that has been dismissed.
Okay.
So only section 34 by applying that it has been held to be void.
Since there was no permission.
Since there was no permission.
But that is the law, isn't it?
That's the law. But I will draw, I had some points for arguing or on the basis of which the substantial question of law has been framed.
Let me just check up whether the permission under section 34 of the so and so was necessary before registration of the deed of conveyance. Whether the civil court has jurisdiction to entertain the suit of this nature, as presumably it is barred under section 51(2). Well, okay.
Second point is of some substance, definitely, because authority under the act was vested with the power to declare it void and cause a eviction of the person who takes possession also. So if the power is vested with the authority under the act, then civil court will have no jurisdiction. Unless it is said that fraud on, but these things doesn't appear on the face of it when there was never any application filed under section 35 seeking eviction before the authority. That would have been a very good point for, or still stands good. But now I am fortified with the change of law in the meantime. Not only that section 34 has been deleted, 34 and 35, but section 36A has been inserted. I am reading out only the language of section 36A.
But what will be, because this cause of action arose when the law was there.
Lord, I will take your lordship, because how had it been not retrospective? 36A, therefore I want to read the language of that 36A.
Yes, please.
This has been so made. This is 36A with the short title, Validation of the Transactions. This is the heading. Then what is said? Any transfer or partition of agricultural land in a locality creating a fragmentation made under the Principal Act before the commencement of this amendment shall be treated as valid.
No, but it doesn't refer to permission.
That is
any sale transaction creating a fragmentation without permission. That is covered by it.
Yes. 34. Any transfer or partition of agricultural land in a locality creating fragmentation made under the Principal Act before the commence.
Mr. Das, I'll ask you to kindly pause here for a moment. Made under the Principal Act. So a fragmentation, sale transaction creating a fragment under the Principal Act can only be permitted after taking permission under section 34.
That is true.
So when it says refers to the Principal Act, it means section 34.
What I would like to say, that if there is a permission, let us say that this 36A has not come into force.
So then only a
permission is enough
to validate a sale.
The transaction is valid.
Yes, yes.
Now we are concerned with only those transactions which are invalid.
Okay.
Under the Act. That is why, under the old Act, if it is invalid, that is why the short title is Validation of the Transactions. Validation of the transactions means which are otherwise invalid.
Okay. All right.
Then any transfer or partition, your lordship knows that even partition was not being effected by the civil courts.
Yes.
If a fragmentation is likely to be created. Or by a transfer. Transfer means any under the Act, old Act means referring to certain acts which were made earlier, not afterwards. Any transfer or partition of agricultural land in a locality creating fragmentation made under the Principal Act before the commencement of the Odisha Consolidation of Holdings, Prevention of Fragmentation of Land Amendment Act 2003. Two things. One is if it is done under the Principal Act, till this Amendment Act 2003 came. Because after 2003 amendment, no further permission under section 34, that is not there in the statute book at all. If under the Principal Act, there was a provision for taking permission in order to validate a transaction, then till that day the amendment came, whatever has been done, any transfer or partition, shall be treated as a valid. Then a proviso has been added, provided that cases where any eviction has been made by the collector under subsection 2 of section 35 of the Principal Act as omitted in this act shall not be reopened. Lest there may be any confusion, this has been added that wherever eviction has already been effected,
সেটা ওটা তাহলে কট অফ ডেটটা কোন
সেটা
ଯୋଉଦିନ ଆକ୍ଟ ଆସିଲା ସେଦିନ କଟ ଅଫ ଡେଟ୍ ହେଇଗଲା କଣ ସେ ପର୍ଯ୍ୟନ୍ତ ଯାହା ଏଭିକ୍ସନ ହେଇଯାଇଥିବ ଯୋଉଟା ନାହିଁ ସେଟା ଭ୍ୟାଲିଡେଟ୍ ହେଲା
ଯୋଉଠି ପେଣ୍ଡିଂ ଥିବ ସେ ପ୍ରୋସିଡିଂ ମଧ୍ୟ ଟ୍ରାନ୍ଜାକ୍ସନ୍ସ ଏଠି 34
this 36A was not before the it had not come during the lower court. What will be
lower court? It has not come even when the appeal was filed before this court. This came only on 29/12/2023.
So we shall have to frame an additional issue, additional substantial question of law in order to.
Yes.
So that is what
your lordship can always frame.
That is all right.
Because it is.
I mean, what will be the effect of this amended section, amended provision, section 36A on this sale transaction held to be invalid by the courts below?
Yes, my lord.
Particularly, then it has to be factually seen whether any eviction has been carried out or not.
That is also because there is also available material source that he had never approached with an application under section 35. He has brought only a suit to declare the sale transaction void.
Maybe as per the advice he has filed out.
Maybe
wrongly maybe, but that suit was decreed.
Suit was decreed to the extent that sale deed is void.
So naturally, and that was confirmed in appeal.
Yes.
So let us. You have to frame an additional.
My lord.
What do you say?
In fact, this amendment, the new amendment of 2023, not 2023.
Yes, 23
is very much vulnerable because it's ultra virus.
It has been declared ultra virus.
The statute itself.
No, it has been declared ultra virus.
No. It has to be declared ultra virus by this honorable court because it goes against the very purpose of the act. No one has challenged so far.
You brought the statute and then.
As long as it has not been declared ultra virus struck down,
it is in force then.
It has been lodged in the statute by way of the amendment. Otherwise, what was the ground of challenge? Leaving aside 36A.
Leaving aside 36A, my lord, for a transaction which is void because of want of permission, remedy is available to a party to file an application before the collector under section 35 of the Act. Collector is vested with the jurisdiction to cause eviction after rendering a finding that the transaction is void. Now, in that context, if we read section 51,
is there a bar?
Section 51
is a bar.
Yes, my lord. Which ousts the jurisdiction of the 51 short title is bar of jurisdiction of civil courts. Notwithstanding anything contained in any other law for the time being in force, but subject to the provisions contained in clause 3 of section 4 and subsection 1 of section 7, all questions relating to right title interest and liability in the land lying in the consolidation area, except those coming within the jurisdiction of revenue courts or authorities under any local law for the time being in force, shall be decided under the provisions of this Act by the appropriate authority during the consolidation operations, and no civil court shall entertain any suit or proceedings in respect of any matter which an officer or authority empowered under this act is competent to decide.
All right. Then we'll carry on next week. The Monday report
Again.
heard in part. Let's this matter next week. Suno, our beta part a week. Huh? All right. Interesting point. Let us see.
The lordship also.
Yeah, I will frame it on that.
That can be framed at any time.
সেটা ফ্রেম করে সেটা কি ফাইনাল হিয়ারিং সরলা পরে কোন আমি ফ্রেম করতে পারি
Ultimately, your lordships will hold it till otherwise.
I cannot.
No, not and in this case.
Unless the state or somebody challenges it out.
Court, this honorable court had.
So that is why I asked him.
So
to be very frank.
definitely.
To be very frank. Once I heard about that, wanted to avoid it by saying that what is the other ground of challenge.
Around it.
Better ସେପଟେ ପଳେଇବ କାହିଁ
ଯାହା ଥିଲା ଯଦି that is enough, then there is no need to look into it.
ସାମ୍ନାରେ ରାସ୍ତାରେ ଗୋଟେ ବାଟ ଅଛି ସେପଟେ ପଳେଇବ କାହିଁକି
Transaction ଯଦି valid ବୋଲି statute କହିଲେଣି that
now you are
validating the invalid transaction. By operation of law, the decree will go.
That maybe that observation can be made ultimately. I don't know what will happen, but I'll have to see the facts. But that 51 thing has to be established by you.
Yes.
That 51 bar. That we will see.